And let the record reflect that we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, we are in the midst of the final arguments. Mr. Cochran, you may continue with your argument, sir.
Thank you very kindly, Your Honor. Good morning, Judge Ito. Good morning again, ladies and gentlemen. Shut up. Thank you. When we concluded last night, ladies and gentlemen, we had discussed a number of things, and I'm sure you have them very much in mind. To summarize some of the things that we talked about and put it in perspective, we talked about a police department who from the very beginning was more interested in themselves and their image. That carried through. We talked about socks that appeared all of a sudden that weren't there. Socks where evidence was planted on them. We talked about police officers who lie with impunity, where the oath doesn't mean anything to them. We talked about messengers, where you couldn't trust the message. We talked about gloves that didn't fit, a knit cap that wouldn't make any difference, a prosecution scenario that is unbelievable and unreasonable. In short, we talked about reasonable doubt. We talked about something that's made this country great, that you can be accused in this country of a crime. But that's just an accusation. And when you enter a not guilty plea, since the beginning of the time of this country, since the time of the Magna Carta, that sets the forces in motion and you have a trial. That's what this has been about. That's why we love what we do. An opportunity to come before people from the community, the consciences of the community. You are the consciences of this community. You set the standards. You tell us what's right and wrong. You set the standards. You use your common sense to do that. Your verdict goes far beyond these doors of this courtroom. As Mr. Darden said, the whole world is watching and waiting for your decision in this case. That's not to put any pressure on you. Just tell you what is really happening out there. So we talked about all those things. Hopefully in a logical way. Hopefully something I said made some sense to you. Hopefully as an advocate, you know my zeal. You know the passion I feel for this. We've all got time invested in this case. But it's just not about winning. It's about what's right. It's about a man's life at stake here. So in voir dire, you promised to take the time that was necessary, and you have more than done that. Remember, I asked you, though, that when you got down to the end of the case, when you kept all your promises about coming here every day and taking these notes and paying attention and, you know, listening to us drone on and on and on, that pretty soon it would be in your hands. And then you couldn't just rush through that, could you? And we tried to make it a little more simple with regard to the issues, but we're going to have 12 minds coming together, 12 open minds, 12 unbiased minds to come together on these issues, and you will give it, I'm sure, the importance to which it's entitled. Please don't compromise your principles or your consciences in rendering this decision. Don't Don't rush to judgment. Don't compound what they've already done in this case. Don't rush to judgment. Have a judgment that is well thought out. One that you can believe in. The morning after this verdict, I want you to place yourself the day after you render the verdict. When you get up and you look in the mirror and you're free, you're no longer sequestered. You probably look for each other, but you'll be happy to be home again. But what's important is, look in that mirror and say, have I been true to my oath? Did I do the right thing? Was I naive? Was I timid? Or was I courageous? Did I believe in the Constitution? Did I believe in justice? Did I do my part for integrity and honesty? That's the mission you're on in this journey toward justice. And now, yesterday I touched briefly on some of Mr. Darden's argument, and we talked a little bit about the fact of his contention about motive. We talked about his analogy about a fuse, and I referred to him as Dr. Darden with regard to what he had to say. And I thought I just would summarize briefly this morning a response to what he had to say and what he tried to weave together. As I said, he talked about an incident in 1985, an unfortunate incident between two people who were married. There was no arrest. There was no physical violence. The one incident in 89, the one he's not proud of, the one he wrote those letters about, the one he apologized for and said he was sorry. And there is no physical violence after that. In the 1993 call, the 911 call, you listen to that entire tape. When they cut it off, you'll remember that it's unfortunate when anyone has an argument. But you listen carefully to what Mr. Simpson is arguing about, what he's talking about, and what the discussion is about. Mrs. Simpson mentions the children, and he says, you weren't worried about the children when you were doing so-and-so on the couch. It's pretty graphic, but any man or woman would be upset over what he's talking about on that tape. There was no physical violence. There's no excuse for him kicking the back door. But by the end, you remember what Cato Kalin said and what the police officer said. They resolved this matter. It was an argument. It was loud and raucous, and they moved on. There was no fuse after that. And this was during a time, you'll recall, that in January of 1992, when they first agreed to separate, you don't hear anything about a dispute. When Mr. Cole Brown Simpson moved out, there was not any question about a dispute. When she got this divorce at the end of 92, there was no dispute. They're both dating other people. He's with Paula Barbieri for that whole year. And then you know it wasn't Mr. Simpson who pursued Mrs. Simpson. It was her who wanted to get back with those kids. You heard Arnell Simpson, and then they agreed, but he put some provisos on that. She couldn't move back in that house. She still kept her own house. Now, who is controlling whom? Who is pursuing whom when he talks about fuse? There is no fuse. They get back together and they try to make it work. It lasts for almost a year. My learned friend has the dates all wrong. It's around Mother's Day when they break up. You remember, there's testimony from Cato Kalin about a pediatric AIDS affair where Paula Barbieri goes with OJ Simpson. It's the early part of May. After Mother's Day, after they break up, with the kids, Sidney and Justin. Now, we know they'd been friends, even when they broke up, they're friends. You know how you know that? Remember the barber, Juanita Moore, nice lady who came in here and talked about OJ Simpson not having dandruff, not having treated hair. She said she came to the house in the first part of May, and there was Nicole there, over at OJ Simpson's house. There's no fuse. Then they go on later that month. They break up, even after being broken up. What does Arnell tell you? That when Nicole gets sick, now these other people who she may be seeing or whatever, it's OJ taking her soup, trying to help out. Now, you do that for your ex-wife or your ex-boyfriend or whatever. There's no fuse. There's no strings attached to that. He goes on with his life because now he's back with Paula. We've been with the year before, and he didn't. And Miss Clark tried to get Cato Kalin to ask, didn't he take Paula someplace in the summer of '93 when she knew they were now back together? And Cato says, no, I don't think so, because they made this arrangement to date each other exclusively. And that's what happened, you see. And so we get all the way back past May into June, and there is no trigger, there is no fuse, there's nothing going on. The only fuse, the only trigger is in Mr. Darden's mind. The evidence isn't there, and they spent all this time about motive. There is none. They were two people who divorced. The case was settled, they had their homes, they moved on. Christian Reichardt tells you that night he was happier than he'd been for a long time because he got his life together and moved on. And so I just wanted you to put that in perspective. And if that wasn't enough, you look at that video of June 12th and the photograph of him with his daughter, and you see whether or not this is a happy man who's just getting on with his life. So when he rhetorically asked the question, why didn't we call Lenore Walker? I say back to him, why didn't you call Lenore Walker? She had something bad to say about OJ Simpson. It wasn't necessary. It wasn't necessary. It wasn't necessary. As you know, we could be here forever, calling one witness after the other. Sooner or later, you were going to revolt, and I wouldn't blame you. Mr. Darden agrees. We had to cut it off at some point. So I hope that when you look about this so-called board of abuse and they have things about a divorce and things up there, you put this in perspective. Absence of motive tends to establish innocence. That's what the jury instruction says. Evidence of other offenses are introduced for a very limited portion in this case. And the bottom line is, the positive things in this man's life, the good days, far outweigh the bad days. And in your life, in all of our lives, we just hope at the end, when we must ultimately meet our makers, that the good days have outweighed the bad days. And in this marriage, the lasting monuments and memorials to this marriage are these two beautiful children. They had more good days than bad days by all of the evidence. These two people loved their children. They may have gone separate ways, but they loved their children. That's why he was back in town to go to that recital where there's so many people, where it's in this auditorium where Nicole Brown Simpson gets his tickets. You know, that's why they're talking in the afternoon, to make arrangements. And she's the one who holds a seat for him. This is what happened on that date. This isn't about any argument. This is a family thing. So Mr. Darden wants to make a big thing and says, well, he had to go out to dinner with Cato. He had to catch a plane. See the evidence for what it is. Understand these things. Put them in perspective. And so you use your common sense. There is no fuse with regard to that. It's important for you to know that. Take a look at that video when you're back there. Take a look at all of the evidence. In this case, Ms. Clark, in her argument on several occasions, said that Mr. Simpson was cut on his razor-sharp cell phone. Well, it's not what the evidence is it? It's not what was said. I read you what Dr. Batten said about that. And so we can use these words, but let's hopefully be accurate as we try to say those things. Now let's go back to where we were when we broke last night. We had started talking about the messengers in this case. We talked briefly about Van Adder and about all of his big lies. His lies become very important because he's the co-lead investigator in this case. From the very beginning, he was lying to you. And it was interesting. When I thought about this last night after I left you, just about 10 days ago, a week or 10 days ago, Van Adder took that stand again, and you saw him. You had a chance to, again, observe his demeanor, and you're smart. You know when somebody's lying and not telling you the truth. I mean, I don't have to go into that. You know, you don't need the jury instruction. You've got this visceral reaction. You've got your experiences in life, and you know somebody who's lying. But, you know, he said something really interesting. It was really preposterous when you think about it. He said, Mr. Shapiro, Mr. OJ Simpson was no more a suspect than you were. Now, who in here believed that? Did he really think he's going to come back in here and we were going to believe that OJ Simpson was no more a suspect than Robert Shapiro? That's what he told you. Big lies. You can't trust him. You can't believe anything that he says because it goes to the core of this case. When you're lying at the beginning, you'll be lying at the end. The book of Luke talks about that. Talks about if you're untruthful in small things, you should be disbelieved in big things. There's no question about that. We've known that all along. So this man, with his big lies, and then we have Furman coming right on the heels, and the two of them need to be paired together because they are twins of deception. Furman and Van Adder, twins of deception, will bring you a message that you cannot trust, that you cannot trust. Let's continue on where we left off then with this man, Furman, who says some very interesting thing in the course of his testimony. And as we talked about Van Adder's big lies, we have Furman's big lies. The Van Adder, the man who carried the blood. Furman, the man who found the glove. You recall that he was asked, as I read to you yesterday briefly, the question well phrased by Lee Bailey, have you ever used this N-word in 10 years? It went right back to 85. And he picked that 85 date. You know why? Because of the Kathleen Bell letter. Just like they knew about it. Picked that date. So he knew he was lying. Honed in on him. You know, liars can be tricky. And so he was, at that point, trying to pin it down for you. 10 years. 85 to 95, this was like in February of this year. Says also he never met Kathleen Bell, this Marine Center. Tells you that Rokar, the photographer, took this photograph after 7 o'clock in the morning. I remember that. Look back through your notes. And the reason he tells you that is because he wants that photograph of him pointing at the glove taken after he supposedly finds the glove at Rockingham. Now, you may not have caught that right at the beginning when this was happening. He says he took the photograph at Rockingham after 7 o'clock a.m. after they returned from Rockingham. You know, they all go over to Bundy after 5 o'clock. Strike that. At Bundy, they all go over to Rockingham at 5 o'clock from 5 to 7. And so it becomes very, very important as we look at this photograph in a few minutes. Rokar then comes here near the end of the case. There's been nobody called to refute him in rebuttal. It says, these photographs on this contact sheet are all taken while it's dark. He says he could tell the difference in a photograph taken an hour and a half before sunrise, 5:41, 5:42, and an hour and a half afterwards. So then why then is this big liar in the crime scene with access to the glove and the hat? Why is he down there pointing at this glove where he's walking and all in the blood and everything when he wants you to believe it's 7 o'clock? Now, we know it's not 7 o'clock. See that photograph up there? That is Mark Furman pointing, you see the envelope? Pointing under this neatly arranged cap and glove supposedly just happened to fall right under that bush in that fashion. That's what you're asked to believe. There he is pointing at it. Well, now, let me tell you why this is important. You recognize Furman, personification of evil. When he's doing that, he's trying to tell you this is some important piece of evidence here. And I just came back from Rockingham. This matches the glove found over there. That's what he tells you. But he's lying again. He's lying, and that's why he's central to this case, because he hadn't even been to Rockingham at that point. And he's tracking in that blood at that point. And that becomes very important, because you remember he slips up and says, in the Bronco at some point. Did he get in that Bronco? Did he put a bloody footprint in that Bronco? Are his shoes size 12? Talks about in the Bronco. He talks about them. Remember, there was a question he was asked about gloves, and Lee Bailey asked him about, he says, he's talking about gloves, and he says, them. Never explained that. When he says them, does that mean 2 gloves? He said, I saw them. Is that 2 gloves? Why would you say them? He's intelligent enough to come and lie to you. So, that picture, that photograph there, that seals their doom. That seals their doom. This man, who in '85, in his mind, started this. This man, who's asked to go over and help OJ Simpson, to notify him and take care of the kids. This man, this perjurer, this racist, this genocidal racist, this is the man. And he says then, inferentially, he didn't plant the glove. But now we know about these photographs when they were taken. And you look, you'll have that contact sheet, and you'll see the photograph of Mr. Cole Brown Simpson. And the last 2 on this roll, taken at nighttime with the flash at 4:30 or so in the morning. Why else is this important? Because they're going to tell you, well, he didn't have an opportunity to get the glove or get access to anything. Remember, they brought all these police officers in here, including Lieutenant Spangler, to say, well, we were just watching Furman the whole time. First of all, you knew that was a lie at the beginning. Why would anybody be necessarily watching him? They're always covering for him anyway. But we knew that wasn't true because when Rokar got there, shortly after 3 o'clock, Rokar goes to that back alley and he sees Risky, who's back there then. Remember, Rokar sees Risky in the back alley. Rokar doesn't even see Furman for like a half hour after he gets there, he says. Then all of a sudden, Furman shows up. Where has he been? What's he been doing? And then Risky is out in the front of Bundy there. And Risky testifies about the taking of this photograph. He wants the place and time later, but he said it's before the sun comes up, before daylight. That has to be, because we've stipulated to it, before 5:41. So inadvertently, he corroborates Rokar. But Rokar knows because he took these photographs. Why then, ladies and gentlemen, is he pointing at this glove when he hasn't even been over there? Why then would they try to tell you he doesn't have time at Bundy when he's by himself for this period of time? He's not with any Spangler, he's walking around by himself. Why then is he walking in that crime scene, and why does he lie to you and said he didn't have access to the crime scene? Now, these are the facts. These are the facts. I haven't made them up. This is what you heard in this case. This is what we've proven. Some of it came in late, some of it came in early. But our job here is to piece this together so that you can then see this. So when he refers to the gloves as them, that's never been cleared up for you, and it can't. It's a Freudian slip. When he talks about in the Bronco, and there was a dispute, well, did he really say that? Remember, the tape was played, the preliminary hearing, and his voice was heard saying, in the Bronco. You can see all these things. He's strolling down to Rockingham. The big man, figuring a way to do this, to carry out this plan, this thought he has in his mind since 1985, to make the big score. And so Rokar severely impeaches Furman about these photographs. And once again, these photographs speak 1,000 words. Concluding about Risky, he said on cross-examination that the photograph pointing at the glove was taken at least 40 minutes before daylight. The sun rose at 5:41, maybe a little bit late, but it was before daylight. And so we know that. That's now clear. Why did they then all try to cover for this man, Furman? Why would this man, who is not only Los Angeles' worst nightmare, but America's worst nightmare, why would they all turn their heads and try to cover for him? Why would you do that if you're sworn to uphold the law? There is something about corruption. There's something about a rotten apple that will ultimately infect the entire barrel. Because if the others don't have the courage that we've asked you to have in this case. People sit silently by. We live in a society where many people are apathetic. They don't want to get involved. And that's why all of us, to a person in this courtroom, have thanked you from the bottom of our hearts. Because you know what? You haven't been apathetic. You're the ones who made a commitment toward justice. And it's a painful commitment, but you got to see it through. Your commitment, your courage is much greater than these police officers. This man could have been off the force long ago if they'd done their job, but they didn't do their job. People looked the other way. People didn't have the courage. One of the things that has made this country so great is people's willingness to stand up and say, that's wrong. I'm not going to be part of it. I'm not going to be part of the cover-up. That's what I'm asking you to do. Stop this cover-up. Stop this cover-up. If you don't stop it, then who? You think the police department is going to stop it? You think the DA's office is going to stop it? Do you think we can stop it by ourselves? It has to be stopped by you. And you know, they talked about Furman. They talked about him in derisive tones now. And that's very fashionable now, isn't it? Everybody wants to beat up on Furman, the favorite whipping boy in America. I tell you, I don't take any delight in that. Because you know, before this trial started, if you grow up in this country, you know there are Furmans out there. You learn early on in your life that you're not going to be naive, that you love your country, but you know it's not perfect. So you understand that. So it's no surprise to me. But I don't take any pride in it. But for some of you, you're finding out the other side of life. You're finding out, that's why this case is so instructive. You're finding out about the other side of life. That things aren't always as they seem. It's not just rhetoric. It's the actions of people. It's the lack of courage and it's the lack of integrity at high places. That's what we're talking about here. Credibility doesn't attach to a title or position. It attaches to the person. So the person who may have a job where he makes $2 an hour can have more integrity than the highest person. It's something from within. It's in your heart. It's what the Lord has put there. That's what we're talking about in this case. And so why don't they speak out? Why do they take him to their breast? Compare how our prosecutors treat Furman as opposed to Cato Kalin. Look at how they treated Mark Partridge as opposed to Cato Kalin. Look at how they embraced him. And now they want to distance themselves. These same people say, oh, he's not important. But the Rokar photograph puts the lie to that. He is very important. And what becomes so important when we talk about these two twin demons of evil, Van Adder and Furman, is the jury instruction, which you know about now. And it says essentially that a witness willfully false. I think Mr. Douglas is going to put that up for us. A witness willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely to a material point unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. Why is this instruction so important? We got the bullet points up there. First of all, both prosecutors have now agreed that we have convinced them, beyond a reasonable doubt, by the way, that he's a lying, perjuring, genocidal racist. And he's testified willfully false in this case on a number of scores. That's what his big lies tell you. And when you go back in the jury room, some of you may want to say that, well, gee, you know, boys will be boys. This is just like police talk, this is the way they talk. That's not acceptable as the consciences of this community. If you adopt that attitude, that's why we have this. Because nobody has had the courage to say it's wrong. You are empowered to say we're not going to take that anymore. I'm sure you'll do the right thing about that. So that what you then, it seems to me, must do is you have the authority. You may reject the whole testimony. You can then wipe out everything that Furman told you, including the glove and all the things he recovered in the glove. That's why they're so worried. That's why when people say Furman is not central, they're wearing blinders. They've lost their objectivity. They don't understand what they're talking about. It's embarrassing for learned people to say that, but they're entitled to their opinions, but we're going to speak the truth. In a courtroom, you are supposed to speak the truth. A witness who walks through those doors, who raises his or her hand, swears to tell the truth. You've heard lie after lie after lie that's been exposed. And when a witness lies in a material part of his testimony, you can wipe out all of his testimony as a judge of the facts. That's your decision again. Nobody can tell you about that unless you feel that the greater probability of truth lies in something else they said. Wipe it out. This applies not only to Furman, it applies to Van Adder, and then you see what trouble their case is in. Because they lied to get in there to do these things. When Van Adder carries that blood, they can't explain to you why he did that. Because they were setting this man up. And that glove, anybody among you think that glove was just sitting there, just placed there, moist and sticky after 6.5 hours. The testimony is it would be dried in 3 or 4 hours, according to McDowell. We're not naive. You understand. There's no blood on anything else. There's no blood trail. There's no hair and fiber. And you get the ridiculous explanation that Mr. Simpson was running into an air conditioning on his own property. So,
Anybody else? All right, the record reflect that we now have our complete jury panel. Mr. Cochran.
thank you. Nice time, my brother. Witness is willfully false. One material part distrusted in others. These two form basically the cornerstone of the prosecution's case. Now, you know, people talk all the time, well, you know, you're being conspiratorial and whatever. Gee, why would all these police officers set up OJ Simpson? Why would they do that? I'll answer that question for you. They believed he was guilty. They wanted to win. They didn't want to lose another big case. That's why they believed he was guilty. These actions arose from what their belief was. But they can't make that judgment. The prosecutors can't make that judgment. Nobody but you can make that judgment. So when they take the law into their own hands, they become worse than the people who break the law because they are the protectors of the law. Who then polices the police? You police the police. You police them by your verdict. You're the ones who send the message. Nobody else is going to do it in this society. They don't have the courage. Nobody has the courage. You have a bunch of people running around with no courage to do what is right, except individual citizens. You're the ones in war. You're the ones who are on the front line. These people set policies. These people talk all this stuff. You implement it. You're the people. You're what makes America so great. Don't you forget it. And so understand how this happened. It's part of a culture of getting away with things. It's part of a culture looking the other way. Of we determine the rules as we go along. Nobody's going to question us. We're the LAPD. And so you take these two twins of deception, and if, as you can, under this law, wipe out their testimony, the prosecutors realize their case then is in serious trouble. From risky to bushy. They came together in this case because they want to win. But it's not about them winning. It's about justice being done. They'll have other cases. This is this man's one life that's entrusted, or will be soon, to you. So when we talked about this evidence being compromised, contaminated, and corrupted, some people didn't believe that. Have we proved that? Have we proved that it was compromised, contaminated, and corrupted? And yes, even something more sinister? I think you'll agree we did. But there's something else about this man, Furman, that I have to say before I'm going to terminate this part of my opening argument and relinquish the floor to my learned colleague, Mr. Barry Scheck. It's something that Furman said, and I'm going to ask Mr. Douglas and Mr. Harris to put up that Kathleen Bell letter. You know, it's one thing, and I dare say that most of you, when you heard Furman say he hadn't used the N-word, that you probably thought, well, he's lying. We know that's not true. That's just part of it, and that's what the prosecutors want to just talk about, that part of it. It's not the part that bothers us on the defense. I live in America. I understand. I know about slights every day of my life. But I want to tell you about what is troubling, what is frightening, what is chilling about that Kathleen Bell letter. Let's see if we can see part of it. And I think you will agree. So I want to put the focus back where it belongs on this letter and its application to this case. You'll recall that God is good, and he always bring you a way to see light when there's a lot of darkness around. And just through chance, this lady had tried to reach Shapiro's office, couldn't reach it. And in July of 1994, she sent this fax to my office, and my good, loyal, and wonderful staff got that letter to me early on. And this was one you just couldn't pass up. Get a lot of letters, but you couldn't pass this one up because she says some interesting things. She wasn't a fan of OJ Simpson's. What does she say? I'm writing to you in regards to a story I saw on the news last night. I thought it ridiculous that the Simpson defense team would even suggest that there might be racial motivation involved in the trial against Mr. Simpson. Yes, there are a lot of people out there who thought that at that time. And you know, you can't fault people for being naive. But once they know, if they continue to be naive, then you can fault them. That's when it is, and that's why this case is important. Don't ever say again in this county or in this country that you don't know things like this exist. Don't pretend to be naive anymore. Don't turn your heads. Stand up. Show some integrity. And so I then glanced up at the television and was quite shocked to see that Officer Furman was a man that I've had the misfortune of meeting. You may have received a message from your answering service last night that I called to say that Mr. Furman may be more of a racist than you could even imagine. I doubt that, but at any rate, it was something that got my attention. Between 1985 and 1986, I worked as a real estate agent in Redondo Beach for Century 21 Bob Maher Realty, now out of business. At the time, my office was located above a Marine recruiting center off of Pacific Coast Highway. On occasion, I would stop in to say hello to the two Marines working there. I saw Mr. Furman there a couple of times. I remember him distinctly because of his height and build. You know, he's tall. While speaking to the men, I learned that Mr. Furman was a police officer in Westwood. Isn't that interesting? Just exactly the place where Laura McKinney met him. And I don't know if he was telling the truth, but he said that he'd been in the special division of the Marines. I don't know how the subject was raised. But Officer Furman said that when he sees a nigger, as he called it, driving with a white woman, he would pull them over. I ask, what if he didn't have a reason? And he said that he would find one. I looked at the two Marines to see if they knew he was joking, but it became obvious to me that he was very serious. Now, let me just stop at this point. Let's back it up a minute, Mr. Harris. Pull it back down, please. If he sees an African American with a white woman, he would stop them. If he didn't have a reason, he'd find one or make up one. This man will lie to set you up. That's what he's saying there. He will do anything to set you up because of the hatred he has in his heart. A racist is somebody who has power over you, who can do something to you. People could have views, but keep them to themselves. But when they have power over you, that's when racism becomes insidious. That's what we're talking about here. He has power. A police officer in the street, a patrol officer, is the single most powerful figure in the criminal justice system. He can take your life. Unlike the Supreme Court, you don't have to go through all these appeals. He can do it right there and justify it. And that's why this has to be rooted out in the LAPD and every place else. Make up a reason. Because he made a judgment. That's what happened in this case. They made a judgment. Everything else after that was going to point toward OJ Simpson. They didn't want to look at anybody else. Mr. Darden asked, who did this crime? That's their job as the police. We've been hampered. They turned down our offers for help. But that's the prosecution's job. The judge says, we don't have that job. The law says that. We'd love to help do that. Who do you think wants to find these murderers more than Mr. Simpson? But that's not our job. It's their job. And when they don't talk to anybody else, when they rush to judgment in their obsession to win, that's why this became a problem. This man had the power to carry out his racist views. And that's what's so troubling. Let's move on. Making up a reason. That's troubling. That's frightening. That's chilling. But if that wasn't enough, the thing that really gets you, she goes on to say, Officer Furman went on to say that he would like nothing more than to see all niggers gathered together and killed. He said something about burning them or bombing them. I was too shaken to remember the exact words he used. However, I do remember that what he said was probably the most horrible thing I'd ever heard someone say. What frightened me even more was that he was a police officer, sworn to uphold the law. And now we have it. There was another man not too long ago in the world who had those same views, who wanted to burn people, who had racist views and ultimately had power over people in his country. People didn't care. People said he's just crazy, he's just a half-baked painter. And they didn't do anything about it. This man, this scourge, became one of the worst people in the history of this world, Adolf Hitler, because people didn't care, didn't try to stop him. He had the power over his racism and his anti-religionism. Nobody wanted to stop him, and it ended up in World War II, the conduct of this man. And so Furman wants to take all black people now and burn them or bomb them. That's genocidal racism. Is that ethnic purity? What is that? What is that? We're paying this man's salary to espouse these views. You think he only told Kathleen Bell, whom he just had met? You think he talked to his partners about it? You think his commanders knew about it? You think everybody knew about it and turned their heads and nobody did anything about it? Things happen for a reason in your life. Maybe this is one of the reasons we're all gathered together here this day, 1 year and 2 days after we met. Maybe there's a reason for your purpose. Maybe this is why you were selected. There's something in your background and your character that helps you understand this is wrong. Maybe you're the right people at the right time, at the right place to say no more. We're not going to have this. This is wrong. What they've done to our client is wrong. This man, OJ Simpson, is entitled to an acquittal. You cannot believe these people. You can't trust the message. You can't trust the messengers. It is frightening. It is quite frankly frightening. And it's not enough for the prosecutors now to stand up and say, oh, let's just back off. The point I was trying to make, they didn't understand that it's not just using the N-word. Forget that. We knew he was lying about that. Forget that. It's about the lengths to which he would go to get somebody, black and also white if they associated with black. That's pretty frightening. It's not just African Americans, it's white people who would associate or deign to go out with a black man or marry one. You're free in America to love whomever you want. So it infects all of us, doesn't it? This one rotten apple. And yet they cover for him. Yet they cover for him. And so how do we do it and what do we do with regard to this man? Well, we call some witnesses. And you recall these witnesses. And before I talk about these witnesses just briefly, and I'm going to conclude my remarks with regard to them, I indicated to you that by the nature of this case, I'm going to pass the baton to Mr. Barry Scheck. You've been great from a standpoint of listening and watching, and I stayed longer than I planned to, but I hope you agree that some of these things were important. And I'll get one more time to conclude with some concluding remarks after Mr. Scheck finishes. The good news is that Mr. Scheck and I will both hopefully finish today and turn it back over to Ms. Clark. So in a day or so, you're going to get this case. You have to hear lawyers talk anymore. Be time to hear you talk. Time to hear you speak out. And I'll be happy. I'll relax tonight, knowing that soon it's going to be in your hands. We're real comfortable about that, all of us. And you should know that. So please give Mr. Scheck the attention that you've given me, and understand that all parts of this case are very important, and it all ties together. because it's all of the evidence in this case went through that LAPD and that black hole over there, that cesspool of contamination, and you listen to him about what he has to say in that regard. Mr. Darden said that in a textbook fashion, we had impeached Mr. Furman. Well, we thank him for that. We take no pride in that, but that's what did happen. In addition to calling Kathleen Bell where you saw her, and she's not the kind of lady that, you know, looking at it, you probably remember her. Unless, you know, it'd be very interesting. You know he's lying about not knowing her. But this man used these words and these racial epithets so much, he probably can't remember who he said it to. He said it to everybody, whoever came in contact with him, on tape. Can you imagine the gall about that? That you would have these racist views, and yet you would put it on tape. Thank God he put it on tape. And so Kathleen Bell came in here and told you the same things in those letters. You saw her. You observed her. You know she told us the truth. They couldn't mess with her because now we had those tapes. And then there was Natalie Singer. Barely knew this man. He was dating her roommate. This man is an indiscriminate racist. He talks so bad that she didn't want him back in the house. What does he say to her? In her presence, the only good nigga is a dead nigga. Now that, probably all heard that expression sometime in your background or somewhere, or heard somebody say that, and that's tremendously offensive. He just says it in the presence of his partner's girlfriend, like they're gonna go on a date. I mean, I hope that in the homes throughout this country, people aren't acting like this. This happened to come to light, but I'd be pretty frightened if I thought that the majority of people in this country acted like this behind closed doors or whatever, because what you do in the dark is gonna come to the light. Remember that. That's what this case is about. It came to the light, and just in time to get it to you. So you saw her on the stand. You saw her graphically. Talk about that. You doubting anybody's mind? He's telling you the truth? Any one of you think she's not telling you the truth? And then finally, we had Roderick Hodge in this series of witnesses. And Roderick Hodge, intelligent young man, understood something about his rights, too. Because after this run-in with Furman and his partner, when he's in the back of the police car, Furman turns around and says to him words that I want you to remember in this case. I told you, I get you, nigger. That's what he tells Roderick Hodge. Why is that important? Because from 1985, when he went on that one call involving the Mercedes, that was this man's mindset vis-a-vis OJ Simpson. I'm going to get that guy. And in 89, when he wrote that report, indelibly impressed on his mind, and in 94, he had his chance. Still in West Los Angeles, he had his chance. So Hodge is important because you can espouse all these epithets and talk theoretically about your racism, but when it's directed toward a human being. And I said to him, Mr. Hodge, tell this jury how that made you feel. He said it made me feel angry and upset and frustrated. It was dehumanizing in a free society. But this man, Furman, does it with impunity. And his partner sat there and heard it and didn't report it. There's something rotten about this kind of conduct. And it's gone on too long. And so, that's why he's important. But the capper was finding those tapes. Something that you could hear, lest there be any doubt in anybody's mind. Laura McKinney came in here, and I can imagine the frustration of the prosecutors. They've had the glove demonstration. They've seen all these other things go wrong. And now they got to face these tapes. And they didn't know how to handle her. Quite frankly, she was a reluctant witness. You know that. Mr. Darden asked her those questions where he became negative with her. She's very smart. Unlike some others who didn't know how to handle it, she says, why are we having this negative conversation? Why are you acting and treating me like this? I didn't try to stop him about cover-ups and things. Why are you asking me these questions? I'm the one who's here under subpoena. Why are you treating me like this? Now, you know it's true because they've heard the tapes. Why are you messing with this lady? You just get so wrapped up in what you're doing, I guess. Why are they messing with this lady? We owe a debt of gratitude to this lady. That ultimately and finally she came forward. And she tells us that this man, over the time of these interviews, uses the N-word 42 times, is what she says. In the so-called Furman tapes. And you, of course, had an opportunity to listen to this man and espouse this evil, this personification of evil. And so I'm going to ask Mr. Harris to play Exhibit 1368 one more time. There was a transcript. This was not on tape, the tape had been erased, where he said, "We have no niggers where I grew up." These are 2 of 42, as you recall. And then there was his actual voice. This is the word text for what he then says on the tape.
They don't do anything. They don't go out and initiate contact from state in the percentage of compromise.
Now, you heard that voice. No question whose voice that is. Mr. Darden concedes whose voice that is. They don't do anything. Talking about women. Doesn't like them any better than he likes African Americans. They don't go out and initiate contact with some 6'5" nigger who's been in prison pumping weights. That's how he sees the world. That's this man's cynical view of the world. That's this man who's out there protecting and serving us. That's Mark Furman. And he's paired in this case with Phil Van Adder. They're both beacons that you look at and look to as the messengers that you must look through and pass. They're both people who've shown that they lie, will lie, did lie, on the stand under oath. And you know, one little parenthetical thing, how these people all try to stick together from a standpoint of law enforcement. The FBI agent comes in here and he talks about, when I bring out the fact that he says that Van Adder says they're not there to save lives on cross-examination, he says, well, he says, I think he was being sarcastic, that Van Adder was being sarcastic, or maybe it was a joke. But, you know, when I listened to that, I thought about that and I said, what's the joke? What's the sarcasm? Is the Constitution, this man's rights to be safe and secure in his home, is that the joke? Is that the sarcasm? It's a sad state of affairs. That's the lead detective I'm talking about. These 2 twin devils of deception. And think about them and keep them in mind. Thank you for your attention during this first part of my argument. I hope that during this phase of it, I have demonstrated to you that this really is a case about a rush to judgment, an obsession to win at all costs, a willingness to distort, twist, theorize in any fashion to try to get you to vote guilty in this case where it is not warranted, that these metaphors about an ocean of evidence or a mountain of evidence is little more than a tiny, tiny stream, if at all. that points equally toward innocence. That any mountain has long ago been reduced to little more than a molehill under an avalanche of lies and complexity and conspiracy. This is what we've shown you. And so, as great as America is, we have not yet reached the point where there's equality in rights or equality of opportunity. I started off talking to you a little bit about Frederick Douglass and what he said more than 100 years ago. For there are still the Mark Furmans in this world and in this country who hate and are yet embraced by people in power. But you and I, fighting for freedom and ideals and for justice for all, must continue to fight to expose hate and genocidal racism and these tendencies. We then become the guardians of the Constitution, as I told you yesterday. For if we as the people don't continue to hold a mirror up to the face of America and say, this is what you promised, this is what you delivered. If you don't speak out, if you don't stand up, if you don't do what's right, this kind of conduct will continue on forever. And we'll never have an ideal society, one that lives out the true meaning of the creed of the Constitution, of life, liberty, and justice for all. I'm going to take my seat, but I get one last time to address you, as I said before. This is a case about an innocent man wrongfully accused. You've seen him now for a year and 2 days. You've observed him through the good times and the bad times. Soon, it'll be your turn. You have the keys to his future. You have the evidence by which you can acquit this man. You have not only the patience, but the integrity and the courage to do the right thing. We believe you'll do the right thing. And the right thing is to find this man not guilty of both of these charges. Thank you very, very much. I appreciate your attention. I think, Your Honor, we may need a brief break because he has to be...
Exhibits.
Judge.
All right. All right, ladies and gentlemen, we'll take a 15-minute recess at this time. Remember all my admonitions to you. We'll see you back here in 15 minutes. All right, we'll stand in recess. The record reflects that we've been rejoined by all the members of our jury panel. Good morning again, ladies and gentlemen. And Mr. Sheck, I understand that you were going to address the DNA issues or physical evidence issues.
I would say.
You may
Thank
proceed.
Ladies and gentlemen of the jury, good morning. Let me join with everybody in thanking you for your service. The frustration, the loneliness, the sacrifice you've made in this sequestration is something that we understand, or we're trying to understand. As the judge has pointed out a number of times, my colleague, Mr. Neufeld, and I, we're from New York City, more specifically, we're from Brooklyn. And we've been out here quite unexpectedly for a lot of months. And I remember when that detective from Chicago testified about having those keys that you stick in and out of the doors and little lights go on. Every day, going in and out of those doors, again and again and again, like Groundhog Day, everything repeating itself, the monotony, the loneliness, the frustration. We sit around, we talk sometimes in amazement at how you deal with this and how appreciative we are. And Well, it's just really an honor and a privilege to present this case to you. And as lawyers that dealt with some of the forensic evidence in this case, which was detailed and complicated, and I'm sure I speak for myself, Mr. Blazier, Mr. Neufeld, Mr. Clark, for the prosecution, Mr. Goldberg, that we had a job. Our job was to make it simple, to make it cogent without sacrificing any meaningful detail. That's our job. And I can't tell you how appreciative we are because you paid attention, you were patient, you followed the evidence. I know that, I watched it. Now, it's our job to make it simple, to make it cogent without sacrificing detail that was important. And sometimes we let you down. I know that. Some days, when we were talking about some of this, it was hard, and we came back to it again, and I think both sides tried to clarify the issues as much as we could. But you never let us down, because those were long days, but you were more than fair with us. I know you followed and paid attention to this evidence. So it is a privilege and honor to have presented that evidence to you. And I must also say that standing before you right now is a terrifying responsibility. It's a terrifying responsibility because we think the evidence shows that we represent an innocent man wrongly accused. We think the prosecution hasn't come close to meeting its burden of proof in this case beyond a reasonable doubt. And we think that the integrity of this system... I'm sorry. What is this?
See.
The integrity of this system is at stake. You cannot convict when the core of the prosecution's case is built on perjurious testimony of police officers, unreliable forensic evidence, and manufactured evidence. It is a cancer at the heart of this case, and that's what this evidence shows. When you go through it patiently, when you go through it carefully, when you go through scientifically, logically, that's what the evidence shows. And you cannot convict on that evidence. There are many, many reasonable doubts buried right in the heart of the scientific evidence in this case, and we have demonstrated them. And we don't have to prove them, but the evidence shows it. So, in the words of Dr. Lee, something is wrong. Something is terribly wrong with the evidence in this case. You cannot trust it. It lacks integrity. It cannot be a basis for a verdict of beyond a reasonable doubt. There was a logo that we showed you in the opening statements that we've reproduced here on a board, and you may recall it. It's a black hole. As you recall, it shows the evidence from Bundy, the evidence from Rockingham and the Bronco, the evidence from Mr. Simpson itself, passes through the Los Angeles Police Department, the messengers that Mr. Cochran was talking about, the lab, criminalists, coroner's office, and then it is tested by the FBI, the Department of Justice, and so on. And if you recall in the opening statements, we said contaminated, compromised, and corrupted integrity of the evidence. Now, the importance of this flowchart is point number one. And you heard Dr. Cotton, Gary Sims, Dr. Gerdes, all the forensic experts told you, with respect certainly to DNA testing, all the testing, if it is contaminated, compromised, or corrupted here, it doesn't matter what the results are by these other testing agencies. Because if it happens within that black hole of LAPD, it doesn't matter how many times you test it. Ms. Clark got up there and said, well, why didn't we hear from Dr. Blake, who, if we didn't have Dr. Blake in this case to be sitting there as the testing was going on while you were already serving on this jury panel, things were being tested. He was up there looking at what they were doing. If we didn't, we wouldn't have even known what was going on in this case. But the point is, by the time it reached the California Department of Justice and Gary Sims, if that evidence, and we've demonstrated, contaminated, compromised, and corrupted, you could do 100 tests. Dr. Blake could test it, Dr. Lee's lab could test it, everybody could test it, and you'd get the same result. So that has not been the issue in this case, and don't be distracted by that. Dr. Terry Speed, you recall him, he gave testimony in this case about error, laboratory error. And he again pointed out, he used that term common mode error. If it happens here, and that's where the evidence is compromised, contaminated, and corrupted, these results are not adding anything. So you ask the question, how did the Los Angeles Police Department, how does any laboratory become a black hole that impairs the integrity of the evidence? Can we have the first slide? Any laboratory has to have three things. You have to have rules and training, you have to have what's known as quality assurance, and you have to have chain of custody security of the evidence. Well, what have we heard about rules and training at the Los Angeles Police Department laboratory? Well, this laboratory is run without a set of rules that everyone knows. They don't even have a manual. Think about that. That's extraordinary. And then they have this draft manual. And it's ignored by the criminalists. Fung and Mazzola, they don't know what's in the draft manual, what procedures there are. And then the laboratory director, Michelle Kessler. Well, she was the acting laboratory director. Actually, one of the real problems here is that at the time of this case, the head of the laboratory was a police officer, not a scientist. But Michelle Kessler, she had that draft manual on her desk for 4 years, going through it. And she says, well, some of this is no good. And they didn't get around to it. So that's how you become a black hole. The testimony is clear in this case. They did not give their criminalists training in state-of-the-art techniques. In particular, of great relevance here, there was no DNA training for the evidence collectors. Now, that's got to be a significant point. Ms. Clark told you in the opening statement that collecting, preserving bloodstain evidence for purposes of DNA testing was as simple as going into your kitchen and cleaning up spillage. Now, we all know that's not true, based on what we've heard in this case. Can we have the next slide, please? Quality assurance. That's a term that's used in bureaucracies and hospitals and laboratories. any place where you're trying to deliver service with integrity. What is going on here? There is a failure to document how you collect the evidence. A fundamental duty, as Dr. Lee showed you, remember with that chart? Fundamental duty of a criminalist to document the evidence. In other words, where it was picked up, how it was picked up, when it was picked up. And we have seen the problems in this case when you can't do that. And you try to reconstruct it later when your memories are gone and you can't do it. Well, that's not done. And failure to document testing is tolerated. Compare the notes at the Department of Justice, Gary Sims and Renee Montgomery, with what you saw from Colin Yamauchi and Dennis Fung. I had to rearrange the notes for Colin Yamauchi, his own notes, when he was on the witness stand, and he goes, that's right. First I took out OJ Simpson's reference sample and made the Fitzco card. Then the next thing I did was the glove. And then the next thing I did, all within that 1 hour and 20 minutes, were the Bundy blood drops. I had to reconstruct his notes for him. And then he goes, that's right. That's the way it happened. I guess that's right. I mean, it had to be when you reconstructed it all. But the notes are not there. And that's fundamental for having any integrity whatsoever. There was no serious supervision of these people. That's just clear. You saw it. This lab was not inspected. This lab is not accredited. This lab is not subjected, certainly the DNA, to external blind proficiency testing, which you know is what you need. Dr. Gerdes told you about that. Everybody talked about that. This National Research Council report, DNA Technology and Forensic Science. Can we have the next slide? Now, this is critical. Chain of custody and security. There is absolutely nothing more fundamental to preserving integrity, forensic evidence, than a chain of custody, than having security. You have to know what you're picking up. You have to be able to document it. Otherwise, bad things can happen, and nobody can trace it. In this case, they did not count the swatches when they collected them. They did not count the swatches when they got back to the laboratory and put them in the tubes for drying. They did not count the swatches when they took them out of the tubes and put them in the bindles. We don't know how many swatches they started with. They didn't book the evidence in this case for 3 days. They kept it in the least secure facility, the evidence processing room, for 3 days without being able to track the items. The lead homicide detective in this case, and we've talked about it a little and we'll talk about it some more, is walking around with an unsealed blood vial for 3 hours. It's unheard of. The other lead detective in this case is taking shoes home. Right out of that, this could be critical evidence. The shoes that their suspect was wearing that night, taking it home. Now, you know, it was amazing when Mr. Fung testified, the extent to which, you know, they've lost all track of the rules. At one point, I asked him, well, would it have been all right if they took the blood home? And he said, sure, you could put, as long as you put it in the refrigerator overnight. Do you remember that answer? I mean, there's no sense of what has to be done in order to give you reliable evidence. None. Think about the Bronco. They finished doing the collection in the Bronco, and then it's abandoned literally for 2 months. There's a box you're supposed to check off, give special care if you're going to collect it for biological evidence. Not checked off. It is sent to Vertels. It is abandoned for 2 months. There are no records of who went in and out of that car. There was a theft. Anybody was allowed in there. And then on August 26th, they're collecting evidence from it. And then finally, and this is, can we have the next board? This is a critical point that I think demonstrates all you need to know about security and chain of custody in this laboratory. The missing lens. The missing lens. Now, this is very important evidence. This is the envelope that's found at the crime scene with the prescription glasses. If you're investigating a case, you're very concerned about this.
In this board?
No, there are not, Your Honor.
All right, thank you.
Now, we can tell, as Dr. Lee pointed out, on this lens, there are smears of blood, trace evidence. There could have been fingerprints from a perpetrator who was going into that envelope. On June 22nd, Dr. Baden and Dr. Wolf got an opportunity just to look at the evidence, not touch or examine or test, just to look. And they saw two lenses there. Made a note of it. February 16th, think about it. That's the first time we got a chance to inspect and just even handle the evidence. You're already sitting here, February 16th. There's something wrong. When we look at it, that lens is gone. There is no report, no record, no investigation of its disappearance. Nobody comes in and tells you what happened. Now, that tells you a lot. Did somebody take this from the laboratory as a souvenir? Did somebody walk off with this? How can that be? This is critical evidence in a case. How can that be? It just vanished down this black hole? Now they're going to say, we're Fort Knox. Nobody could get to the evidence in this case with our evidence tracking system. Now, I should just tell you in passing, I'm sure you caught it, that even when it's booked into the evidence control unit, and it's supposedly being tracked, they didn't say their computer tracking system was a chain of custody system. It isn't. They'd have all the evidence item in boxes, like the sock and the blood drops, and they'll put them in the serology freezer, and they're in a box there. Then somebody will hit the computer, and they can go in, and then they can take any item they want out of that box. It's not tracked by specific items. There is no good security in this system. There's plenty of access if you want to tamper with evidence, if you are authorized personnel, if you are a lead detective, if you are somebody there, it can happen. And the missing lens tells you all you need to know. What is going on here? And if they come back and say, well, maybe Dr. Baden and Wolf are wrong, there was no lens to begin with. Well, that's even weirder, isn't it? What kind of killer takes a souvenir like this? How does that fit in with their theory? The missing lens is a serious problem in this case. Now, the black hole symbolizes something else. You know, science is no better than the methods employed and the people who employ it. DNA is a sophisticated technology. It is a wonderful technology. But there's a right way to do it and a wrong way to do it. The issue in this case is not, is DNA good or bad, DNA technology? The issue is right or wrong. So Ms. Clark gets up here and tells you, well, Dr. Lee said DNA is okay, therefore the DNA evidence in this case is okay. That's ridiculous. Dr. Lee said, right way, wrong way. Dr. Lee is one of the authors of this report. Right way, wrong way. And something else. During the cross-examination of Dennis Fung and Andrea Mazzola and Mr. Matheson, we brought out a pamphlet entitled Collection of DNA Evidence, How You Should Do It. It was a pamphlet that was put together by Dr. Henry Lee in association with the FBI. Mr. Fung had only heard of it, if you recall, after he was prepared to testify in this case, not before they all went out and collected the evidence. And in that report, as it was established, you know, and Agent Bodziak, I don't know if he really knows a lot about Dr. Lee, as he said. He had limited knowledge. I mean, he's questioning whether he goes to crime scenes. The FBI is saying, well, how do you collect DNA evidence at a crime scene? Dr. Lee writes the manual. And in that manual, they say you don't put these swatches in plastic bags. Because you put wet blood swatches in plastic bags, you're going to degrade all the DNA in them. And they sat here debating whether you could do that for months. And as we'll talk about it now, they're trying to turn that argument around. But it's just plain that they didn't know what they were doing here, and you can have the most sophisticated technology in the world, and if you don't apply it correctly, you can't trust the results. There's no compliance with the NRC report. There's no compliance with the kind of standards that you would require in a life and death situation. And this is a life and death situation. And that's what you have to demand of a laboratory. And Dr. Gerdes is a man that deals with life and death situations, bone marrow transplants, organ transplants, disease diagnosis. He came in and told you about the standards that we demand, that we require, that ought to be the minimum. They're not close. You can't brush this off, as Ms. Clark did in her arguments, by saying, sloppy criminalists, sloppy coroner. And that's all she said. I fully anticipate that most of the matters I'm going to be addressing to you, she's been planning to address in her rebuttal summation, because she certainly didn't address them in her closing argument, did she? You can't just say sloppy criminalist, sloppy coroner, big deal. She said DNA, it's an insult to your intelligence, frankly. DNA is used to identify the war dead, therefore accept all the evidence in this case. That doesn't answer the question, does it? As a matter of fact, the DNA test she's talking about are something they call mitochondrial DNA tests. It has nothing to do with the tests in this case. And the war dead has nothing to do with what was going on in this case. Zero. It's not an answer. It's not this case. It's not the techniques. They argue that defense has to prove exactly how, exactly where, exactly when tampering occurred with any of this evidence. That's not our burden. They have to prove to you that this evidence has integrity beyond a reasonable doubt. And you know, when people tamper with evidence, they don't do it on videotape. They try to do it with some stealth. They try to cover their tracks. And as Mr. Cochran's pointed out, and if you think about this evidence, it wouldn't take more than 2 bad police officers to do this. And a lot of people look the other way. Could we have 2.01? Now, the way that I'd like to organize the rest of my remarks for you is a systematic study of the essential facts. And the circumstantial evidence charge in this case talks about, key point, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proven beyond a reasonable doubt. Each essential fact. That's what's special about a circumstantial evidence case. For each essential fact, they have to prove it beyond a reasonable doubt. If they fail, if there's a reasonable doubt about an essential fact, you must acquit. Those are the rules. And when you're looking at a piece of circumstantial evidence, if it is susceptible of 2 reasonable interpretations, one points to guilt, one points to innocent, you must adopt the one that points to innocence. We have the next chart. So what I propose to do with you today, and I'll try to do it as quickly as I possibly can, is go through what we believe are essential facts. Now, we don't have to prove anything. And we don't have the burden of proof here. And I'm going to confront each and every one of these essential pieces of evidence in this case and raise a reasonable doubt about it, more than a reasonable doubt, many reasonable doubts. But if they fail in one of their essential facts, you have to acquit. We're going to go through the socks. Another reason I put this up here is that you'll know when I'm getting close to done, and you can follow along. The socks, the stains on the back gate, the missing blood, the hair and fiber, the evidence of struggle at Bundy, the testimony of Dr. Baden and Dr. Lee, the Bronco, the Rockingham glove. That's what we'll be discussing this morning. Let's start with the sock. We know that on June 13th, when Mr. Fung went to collect the sock, not yet, He saw it on the throw rug. Not yet. And he did not see blood. He did not see soil on the carpet. He did not see any trace evidence around, not on the stairwell, not on the carpet leading into the bedroom, not anywhere. There's supposedly a stain, an ankle stain, on these socks. You saw it cut out, about 1.5 inches, huh? More DNA in that than anything in this case. Wouldn't that, if it were there, have left a transfer, some specks, something? If they're in a struggle? You have children. I have children. You ever see them go out to play in dirt, like that closed-in area at Bundy? Get into some kind of ruckus, socks come back, they're filthy. Would have to be here if there's anything on them at all. Nothing. Nothing there. Now, Mr. Fung is looking for blood. These socks are the only clothing they take. It's logical as a criminalist, as he admitted on cross-examination, that he would be looking at the ankle area, the one they would look to first because that would be the most likely exposed. Sees nothing. He's running around trying to do testing of anything that looks like blood. No test of the socks. Then, on June 22nd, Dr. Baden and Dr. Wolf are permitted to go to the crime lab. And Michelle Kessler shows them the socks. They see nothing. Now, we get to June 29th. This is very interesting. On June 29th, the defense wanted access to samples, split them. And the criminalists, Matheson, Kessler, the head of the laboratory, and Yamauchi, are going through all the evidence in about a 5 or 6 hour period. Right there, they're going through all the evidence to make an assessment of what kind of testing could be performed, of what kind of biological material or blood would be on any of these pieces of evidence, to see PCR testing, RFLP testing, how they could be divided. They also, Mr. Yamauchi said, they were literally measuring the size of the swatches and making assessments and making examinations. What piece of evidence at that point is more important to these people than the socks found in Mr. Simpson's bedroom? Wouldn't you look at that? And they told us that they took white paper and they put the socks on the white paper, and if there's blood, 1.5 inches on that ankle, you know, you saw it every time that we put something down. Little specks would come off. Even when Miss Clark put those gloves on the very first day, we actually had it on white paper, used, you know, the plastic gloves, and little pieces of trace fell off. And we actually pulled those together, put them in a separate exhibit, because these kinds of things fall off. If there were that stain on the sock, that big stain on the sock, they would have seen it. Gary Sims told you. He was disturbed by it, that a trained criminalist should have seen it. You use light that's sufficient to look at what you're doing. They're now telling you we didn't have light, we didn't look at what we were doing. Please. Where I come from, that don't pass the laugh test. Now, what is the summary? On the socks, on the report they do, on June 29th, dress socks, blood search, none observed. None observed. Tells you all you need to know. Or none obvious, I'm sorry. Can't even read that. It's either none observed or none obvious. They have two different phrases, one on the handwritten report, one on the typewritten report. Okay. Then suddenly on August 4th, Mr. Yamauchi can't remember. It was some kind of general inventory. Mr. Matheson might have asked him. He can't remember what the direction was. It wasn't specific to the sock. Somebody said, go look at this stuff. And then, for the first time, they find the stain on the ankle. Now, we have evidence of the wet transfer, going through surface 1, surface 2, through the little holes in the sock to surface 3. It's pretty simple. If there's a leg in those socks, you can't have the transfer. Professor McDonald and Dr. Lee came in, and they showed you the pictures of the little red balls. And I don't think it's even being seriously contested that this is evidence of a wet transfer now. They're not contesting it, really. Can't get it when the leg's in the sock. Their testimony stands unrefuted. There was no bloodstain expert that came in here and said, that's not a wet transfer, Dr. Henry Lee, Professor McDonald. Dr. DeForest didn't show up here. Why? Now, during the course of cross-examination of Dr. Lee and Professor McDonald, the prosecution sent up some hypothetical explanations for this that I'll review with you. And each one of them was rejected by Dr. Lee, Professor McDonald, but Dr. Lee in particular, as I recall, I think they gave him all of them, as highly improbable. Lots of things are possible, but he said these explanations were highly improbable. Number one, the idea that at the time of the killings, there could have been a touch with the finger from a victim of Mr. Colbrand Simpson on the leg, and that it wasn't dry when Mr. Simpson somehow got into that Bronco, came back to Rockingham, avoided Allen Park, ran down the side, left no bloodstains, hit the air conditioner, hit the stucco fence, leaving no trace, somehow came in, all with the bloody clothes, went up the stairs, left no trace of blood, left no trace of soil, left no trace of berries, got into the house, took off the socks, left them there, and then it's still wet. So if it's still wet when he takes off the socks, you get the transfer to surface 3. Well, there's a big problem with that. Then you should have seen something on the carpet if that's what happened. It doesn't make sense. It doesn't fit. Then the next explanation is on August 4th, when Mr. Yamauchi did the pheno test, taking the swab and brushing the stain to see if it were blood, that somehow created wetness that transferred into the third surface. Or, well, Dr. Lee and Dr. McDonald said that doesn't make sense when you look at the stains, because if that brushing had occurred, you would see a diffusion. And you don't see that kind of diffusion, and that's not the way you would do the test anyhow. Just touch it. Couldn't cause that kind of transfer through to surface 3. Highly improbable, said the leading forensic scientists in America. Sweat. Next explanation is going to be sweat. Well, there was a stain from the crime scene, but sweating in the sock, and then the sock is taken off, and then somehow by process of sweat, it transfers to surface 3. Dr. Lee and Dr. McDonald said, ridiculous, highly improbable. You'd see that same diffusion as with the pheno test, and we don't see it. The next explanation. When Mr. Simpson is taking off the socks, he coincidentally has a finger that touches surface 3 opposite the ankle stain. So it's not Nicole Brown Simpson's blood that is on surface 3. It's Mr. Simpson's own blood that he accidentally touched exactly opposite. That's a ridiculous coincidence. That doesn't pass the lab test. That's the other explanation they floated. Then another explanation they tried. They showed Dr. Lee the new picture of the sock. Remember how they were folded up? They said, well, maybe blood of Mr. Simpson's, when you fold the sock over, landed on surface 3 coincidentally opposite the stain when they were bundled up, and that's what created it. Again, rejected as a ridiculous, highly probable coincidence. Now, none of these things make sense. Ms. Clark also said, you know, there's a tiny spatter of Mr. Simpson's, some blood at the top of the socks, Mr. Simpson. She says, well, there's spatter there. Well, you know, Professor McDonald said there's no spatter. Gary Sims doesn't pretend to be a bloodstain expert. Professor McDonald, Dr. Lee, the leading experts in this area. They didn't bring in anybody. It's ridiculous to say there's spatter there. And if it's spatter of O.J. Simpson's blood, how does that happen? What, did he bleed so much that created a puddle and spatter on the top of the socks? Nonsense. The point is, every explanation that they're desperately trying to come up with is a highly improbable inference. The most likely and probable inference is the one that is not for the timid or the faint of heart. Somebody played with this evidence, and there's no doubt about it. And you know why there's no doubt about it? Because they got so upset in the opening statement about the socks, about the Batgate, so upset that they sent it to the FBI. And Mr. Harmon wrote them a letter saying, please refute the defense theory that somebody tampered with this evidence. Please refute it. Those were the words. Not exactly an objective way of sending it out. Please test this for EDTA. Please refute what the defense has to say. And Agent Martz never testified in the prosecution's case. And you know why that is? And that's really all you need to know. Because he couldn't refute it. Because it's an inference consistent with innocence that they can't refute. There's EDTA. How does that happen? There's EDTA there. So if we could have slide 4. The sock. No blood on June 13th when it's collected. No blood on June 22nd when Dr. Lee, Dr. Baden, and Dr. Wolf see it. They looked for blood on June 29th on a lab paper with reasonable light. 3 people with 25 years of experience, and they don't see it. Most important piece of evidence, examining it for purposes of court. The wet transfer to surface 3, unrefuted, and EDTA. Now let's think about it. Is this coincidence? Kill that, please. Is this coincidence? All these things with the sock? Or is it corroboration? I say it's corroboration that something is wrong. Something is terribly wrong with the most important pieces of evidence in this case. It is a cancer that is infecting the heart of this case. You cannot render a verdict beyond a reasonable doubt based on evidence like this. So if we apply 2.01, an essential fact, the socks, Ms. Clark said, an essential fact, whose interpretation is the most reasonable? And even if you give some of those cockamamie explanations some credence, and you say, well, maybe ours is certainly reasonable enough for you to, you must adopt it. And if you must adopt it, really, where does that leave us? Because, you know, there's another instruction that I submit has some relevance here. Can we have the slide now? Now, you've been instructed that a witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who has willfully testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. Thank you. Now, yes, that applies to witnesses, but I would argue to you that by analogy, it applies to the messengers who are bringing you this forensic evidence as well. Because let's just think about the socks. The LAPD officers and lab people who are responsible for the collection of this, for the chain of custody, for preserving the integrity of this evidence are the same people that are bringing you everything else. Remember what Dr. Lee said about the socks? He said it's like eating a plate of spaghetti. Looking through the bowl of spaghetti, I think he said, you see a cockroach. Do you then take every strand of that bowl of spaghetti to look for more cockroaches, or you just throw it away and eat no more? In your deliberations, somebody may say, all right, I have a reasonable doubt about this essential piece of evidence, the socks. I have a reasonable doubt. It's reasonable that they manufactured this piece of evidence. But let's put that aside and look at everything else. Well, just wait a second. Just think about what that means. If they manufactured evidence on the sock, how can you trust anything else? How, in this country, in this democracy, can they come in? There's no doubt Furman's a liar and a genocidal racist. There's no doubt about that. But there's really no doubt either that they played with this sock, is there? And if that can happen, that's a reasonable doubt for this case, period. End of sentence. End of case. It really is true. Not in this country. It's a test of citizenship, not in this country. Now let's go to the back gate. Can we have the next slide? Because, you know, there's more. There's more of this cancer. We don't have the rest of that? Put it all up. 117, put it all up, Howard. 117 was the stain taken from the back gates. And you know, there was something very strange about it, wasn't there? The blood drops at Bundy were degraded and had extremely low DNA concentrations. 117 had enough for an RFLP test. It was 27 times as much as 47, the first blood drop, 45 times as much as 48, 270 times as much as 49, 51 times as much as 50, 11 times as much as 52. This slide, like most of them I'm going to show you, is in evidence. And you know who brought us that testimony? Gary Sims from the Department of Justice. We have the next slide. That's 117, the one on the gate. Do them all. This is 115 and 116, the one on the lower parts of the gate. 15 times as much as 47, 22 times as much as 48, 135 times as much as 49, 25 times as much as 50, 6 times as much as 52. This supposedly has been out there from June 12th to July 3rd. And until that, there's no question. Sunlight degrades DNA. Moisture and bacteria degrade DNA. Why are these concentrations so much higher? And another point. There's DNA concentrations, but there's also a separate test, as you've learned, when you look at those yield gels for degradation. These samples are not degraded. How can that be? Nothing. Now, there's something interesting here, too. Prosecution is now saying, well, it's on a different surface than the Bundy blood drops. Bundy blood drops are on cement. This is on a metal gate, painted metal gate. So something magical about this that will prevent it from degrading at all in over 3 weeks. Remember, the blood drop number 50 is just a few feet from this bottom portion of the gate that's very, very close to the surface and all the same environmental insults. But you know what proves this argument totally fallacious? And I asked this question of Gary Sims, and you can go back. Remember the blood from the handrail? That was one of the last questions I asked him. It's very curious to me that they've never typed that. They're still testing. Remember the blood on the handrail as you're leading up Bundy? Same kind of surface, totally degraded. Remember the samples from the front gate? There was blood on the front gate. Gary Sims's testimony, no question about that, severely degraded, just like the other samples from Bundy. So those are the same kinds of surfaces. So this explanation, don't pass the laugh test. Well, what's the other explanation that Ms. Clark offered you? Now, this is a whopper. She said, well, it's the plastic bags. I mean, that's rich. They spent weeks trying to deny that putting samples in plastic bags doesn't degrade the DNA. Well, it does. I mean, you know that from the moisture. So now they're saying on July 3rd, when Fung made this collection, he put these swatches in a plastic bag, but he didn't let them cook as long in a truck as he did on June 12th. It's our own incompetence. That's the explanation. That accounts for these differences. Well, you know, that doesn't work either for a number of reasons. Number one, they were going, as you recall, on a tour of the crime scene. And Fung, apparently right away, all of a sudden, they found this stuff on the back gate. And there's no testimony, zero, as to how long it took Dennis Fung to bring those back to the evidence processing room, or how long he had them in a plastic bag, or what other things they had him doing. There's no testimony that he immediately went back to the lab, he didn't continue with them in the tour, or anything like that. And you know why it's significant that they can't come in here and argue that when they don't present evidence? Because they could have. Because we know that there are records of when you go back into that evidence processing room and get in the door, they could have demonstrated, if they really want to put this argument before you, they could have demonstrated how long it took. Or they could have brought him back here to testify about it. But frankly, if they brought him back here to testify about that explanation so late in the game, you wouldn't have believed him, would you? So they can't use this plastic bag theory, and they can't use that it's a different surface. They can't. It doesn't make sense scientifically. It doesn't fit. So what's going on here? Now, there's another thing. They're going to say, well, you know, Officer Risky, Phillips, I believe, Furman, Rossi, that night when they were entering the premises, the back gate, they had their flashlights, and they were looking up and down, and they think they saw some blood on the back gate. So they all testify to it, so you know it's there. Well, first of all, we know, you've been there, that this gate was rusting. There were all kinds of darknesses, imperfections. There were berries all over there. There's all kinds of discolorations. And what did they really see with their flashlights? It's not clear what they saw with their flashlights. But you know what's very, very interesting is that Lang said to Fung, go look. There's blood on the back gate. You should go look. Or we've heard reports there's blood on the back gate. Now, this is very interesting. Could we put up the diagram? You may remember this. This is the diagram that Fung did of the back gate. Pull back on it. And you'll recall the testimony. These are the numbers you see, 115, 116, all those numbers, right? Those are the photo numbers. You recall how they did the collection? That they put down a photo number, not the evidence item number. So they started on the walkway with 112, and they put down 112, and that was sample 47, and they collected that. Then they went and they put down number 113, and that was sample 48, and they collected that. Then they went down and they put down 114, and that was sample 49, and they collected that. Then they put down 115, and that was sample 50, and now we're right by the back gate, and they collected that. Now, this is what shows you there was no blood on the back gate. Because at that point, what do? They go to the front gate. They walk all the way back to the front gate where the bloodstain patterns are. That's 116. And then they go back all the way to the end of the driveway and they get the last blood drop, number 52, 117. Why did they go all the way back? I'll tell you why. Because Detective Lang had told Mr. Fung, as he testified, that there was blood on the back gate. And they looked, he'd heard reports of it, and they didn't see any blood on the back gate. So the only blood they saw on a gate was on the front gate. So they went back and collected 116. And you know what else shows you that? Can we have the picture? Where is it, Mr. Fung? They took no pictures of any blood on the back gate 117. There's some discoloration there that may be consistent with 115 if it's blood at all, but there is no 116. So there's no pictures either. Thank you. And what else? What else? What else? There's EDTA on the stains from the back gates. So can we have a chart on this? Let's look at the back gate. No documentation or photos on June 13th. Discovered on July 3rd. High DNA concentration. No degradation. EDTA. Coincidence or corroboration that something is wrong? Something is terribly wrong. There is a cancer at the heart of this case. This is a reasonable doubt. You put this together with the sock. How many cockroaches do you have to find in the bowl of spaghetti? This isn't made up. This isn't invented. These are facts. How could all of this be? How can, this is a reasonable interpretation of the evidence based on solid fact. You cannot, on your oath, reject this and say, it never happened. You can't. It's a reasonable doubt. Now let's discuss EDTA, because that's obviously an important issue. They asked for the tests to be done after the opening statement, refuted, and they didn't put them on because it doesn't refute. Reasonable interpretation of the evidence that there's EDTA there, consistent with having come from a purple top tube, on the face of it. They didn't put them on. We had to call them. But you know, there's a very, very interesting point that you might have missed in Dr. Reeder's testimony when we compare Dr. Reeder's and Agent Mart's. And that is, January, there was a gentleman named Henkhaus, works with the LAPD Science Division. And they were interested, after the opening statement, in seeing whether or not tests could be a method to detect EDTA. Yes, of course. That was a letter with a number of citations on it. Before the testing was done, before they knew he was even going to appear as a defense witness, they reached out to Dr. Frederick Reeders. Why? Because Dr. Frederick Reeders, a PhD, a distinguished teacher, he runs a reference lab outside of Philadelphia, reference lab. People go to this laboratory when you want to develop toxicology techniques which are specialized and sophisticated because he is experienced, he is knowledgeable, he is learned. They asked him for work about EDTA. You know why else? As Dr. Reeders testified, he has expertise in EDTA, in its use to treat people for lead poisoning. He's been working with EDTA for, I think, something on the order of 30 years. He's the expert you would call to interpret the data. So they asked him for references. And now they want to tell you that he's out of his mind, that he is not reasonable in his interpretation of this data and he shouldn't be trusted. Very interesting, isn't it? Now, you know, when you evaluate the testimony of Agent Martz and Dr. Reeders, there really isn't that much disagreement. And remember the circumstantial evidence charge about whether if there's two plausible, reasonable interpretations, you have to take the one that goes with innocence. There are three questions. Is there EDTA there? Dr. Reeders says yes. Agent Martz says could be consistent with EDTA based on the MSMS readings. If it isn't EDTA, says Martz, I don't know what else it could be. Next question. If it's EDTA, how much is there? Now, both of them agree that it is in parts per million, not parts per billion. And both agree, when you examine the testimony, that if it is in parts per million, it cannot come from the EDTA we ingest in food that then is secreted into the blood. You don't have parts per million that way, because if you did, you'd have serious health problems. You wouldn't clot. You'd bleed to death, as Dr. Reeders was pointing out. The next question, and this is where they parted company, is the amount of EDTA here sufficient to have come from a purple top tube? Agent Martz says, Dr. Reeders says, unless you were treating somebody for lead poisoning, injecting EDTA into them, that is the only reasonable explanation for parts per million in these samples of EDTA. Agent Martz says, no, I can't really say, because I would expect there to be more EDTA in a sample left for 3 weeks on the back gate or on a sock, that I'm seeing 6 months later. But he never did a single experiment to find out how much you would expect to get from stains that are months old and have subjected to environmental insults. And you saw that there were quantitation problems when they tested it. It would go up and down. So when you look at it, look at the credentials, Martz versus Reeders. Reeders has far more experience with EDTA. They wanted to hire him, or they consulted with him, I should say. Dr. Reeders works with the FBI. They go to him and consult, as you heard, on cases. He was working on a case for them, with them at the time he came here to testify. He runs a reference lab that specialized in these issues. Even though he does not have the $750,000 machine yet, the MSMS that Martz is using, he understands it, seen it before, interpreted data from it. He's getting one soon. So it's not a question of the machine, it's a question of the expertise to understand the data. Agent Martz, he has a bachelor's degree. He had some trouble with pi. I don't want to belittle that, but he didn't even, there's some disturbing parts of his testimony, let's face it. He didn't even consider the validation studies that had been performed by others at the FBI laboratory. They're going to make a big deal about these, he didn't look for that 132 daughter ion. I promise not to talk about daughter ions to some people, but he didn't perform the test to find that. All the digital data he threw away. He comes up with this thing where he says he tests his own blood and he finds some level of EDTA in it, but he threw away the documents about what he did. He put it in a test tube for 2 weeks that has silicon in it, has a red stopper in it that could be a source of EDTA. He doesn't go and test anybody else's blood. I mean, this would certainly be a phenomenon if we found parts per million in all these kinds of blood, or his whole method is screwed up. Why didn't he test more? You know, they're going to come back and say, well, Dr. Reeder should have done more of a test on these leftover samples. Excuse me. That's what they should have done. Well, you know, it's their burden. It's their burden, after all. They say it's key evidence. She said it's their defense. Well, then why not get some real studies or do more studies or save the data or present something to this jury that's credible to disprove it? Ms. Clark gets up here and says, we have disproven that this could be EDA from a purple top tube. Dr. Reeders has no basis whatsoever for saying this. It can't be a reasonable interpretation of the evidence. Well, saying it doesn't make it so. It's their burden. They have to disprove this beyond a reasonable doubt. They have not. An essential fact, that circumstantial evidence charge says. An essential fact. Let's be proven beyond a reasonable doubt. Ms. Clark got up here and told you this was essential. Have they done that? No, they haven't. That is many, many reasonable doubts. Now I'd like to talk about missing blood. And I think that we can talk about this in the following way. Access, opportunity, and the smoking gun, Nurse Thanoparatus. Could we have the first picture? Now, Detective Van Adder, the man who carried the blood, picked up blood from the coroner's office of Nicole Brown Simpson and Ronald Goldman, blood tubes that contained EDTA. Let's show them all. Remember these? These are pictures of both sides of the tubes. Just pull them out. I think the point is made. One after another, covered with blood. He got those from the lab. He carried those. Those tubes, the testimony is, have EDTA in them. He carried them on June 15th. Now, we do not have records. There are no records of the amounts that were initially put in those tubes or where he went, how long he went. No real evidence that we can examine about that, but he carried it. On the other hand, when we turn now to Mr. Simpson, that's enough. Yeah, he testified. He took him from the coroner's office and he brought him to LAPD. But there is no record of how much was initially put in those tubes, so we can't retrace the amounts. Now let's look at the handling of the defendant's, Mr. OJ Simpson's reference file. Detective Van Adder, as Mr. Cochran pointed out, was so upset about how this goes that when he was asked, well, when did you get the blood vial, he said 3:30. Well, it was 2:30, we know that. His testimony is he gets the vial of blood and he goes off and he has a cup of coffee and he's walking around Parker Center with a blood vial in an unsealed tube. And as you know, the rules are you're supposed to book it immediately. You can book it in that building, Parker Center. You can walk a mile, go a mile away, it takes just a few minutes, and you book them at Piper Tech, where the SID lab is, and you buy a DR number, which is the number for the case, and the case starts. That's what the rules say. But that's not what they were doing. Now, can we have the next? That's not it. I want the instruction. There are instructions on this envelope that we reviewed, I think, with Mr. Yamauchi, which are fascinating. It says that the investigating officer requesting withdrawal of blood shall, when the vial is returned to you, enter your initials, shake the tube vigorously. When the affidavit is completed, sign below as a witnessing officer and seal the vial in the completed sealed evidence labels. In other words, what you're supposed to do after you get the vial from the nurse is you put it in this envelope, and the instructions say, using completed sealed evidence labels, you seal the envelope. Now, he's been a detective a long time. He knows the rules. And the testimony is he's never done this before, not seal it, not walk around with the blood. And now there's something else, and it's a little hard to see on this photograph. And we tried to get the original here, but at the very, very bottom, there's something really weird that you can inspect. It's covered over by the label. You see the date? I declare this is not apparatus. I declare under penalty of perjury the foregoing is true. And then it says 5/10/94. May 10th, 94. Well, wait a second. This was June 13th. This envelope is an old envelope in the lab. It's something that Mr. Paradas had hanging around there for some reason. It says May 10th, 94. It's an old envelope in the lab. Why is that? What's going on here? They're not following the rules. He's grabbing this envelope. He's carrying around this blood. It doesn't make sense. It doesn't fit. It's a serious problem, isn't it? Now, the next thing that we have is this misnumbering, you recall, of the blood vial. And Mr. Fung, as you remember, was stumbling over it. There's a problem here. The sneakers were brought in by Detective Lang the next morning, and they were put in as 17. The blood vial is numbered as 18, indicating receipt the next morning after the sneakers, and 19 is this hair that Mr. Fung took off the Rockingham glove, all that morning of June 14th. And you recall the testimony that we had in this case, that Mr. Fung remembers he had such, problems. He said, well, and I walked out of Rockingham. I had the tube either in my Ponzi box, that metal box, or I had it in my hand in the envelope, or I had it in a brown paper bag and I put it into the truck. And then we showed him videotape, and all of a sudden it changed, and we had videotape of people inside and Van Anna bringing in the envelope. And now the state of the evidence is that Andrea Mazzola was given a black trash bag, and that she didn't know, nobody told her that the envelope had been put in it, and maybe some of those other evidence cards. And you saw the video where they walk into the truck and they throw that trash bag inside the truck, and they go back to the lab, and now the testimony is that they leave it out on a table in a trash bag after they, put the swatches in the test tubes, and they leave. Now, and they don't even refrigerate the vial. Now, this is a very odd story, to say the least. And I think what's really peculiar about it, when you get down to it, is the way the testimony came out. Andrea Mazzola said something very interesting. She said that when she saw the next morning, June 14th, the blood vial in the black trash bag, she realized for the first time that she had been the one that carried the blood vial out of the Rockingham residence. So she's saying that she knew that on June 14th. You with me? Now, we had all this, we spent 3 days on this, if you recall. Mr. Fung couldn't remember how the blood vial was carried out. These prosecutors knew that there was misnumbering, that there was a problem with this blood vial and its transfer. They knew it was a problem. Now, if Ms. Mazzola had known since June 14th that she had carried this out in a plastic bag, because she realized it looking at that at the next moment, how come nobody was told this? Why didn't somebody know this? Why didn't they interview these witnesses before they got on the stand for 8-10 days apiece? And this was obviously a crucial problem, because there's something wrong here. And of course, when she ultimately testified, poor Miss Mazzola had to go over and sit on the couch and close her eyes for 20 minutes because she was tired and didn't see what went on in the foyer. Now look, I'd submit to you, I don't think that's all credible evidence. I think there's something really wrong here, but, you know, you don't even need it, really, if you think about it. Because in terms of access and opportunity, all that really matters is what nobody can deny. And that is Detective Van Adder is walking around with a May 10th envelope that he should have sealed and he should have booked for 3 hours at least, unaccounted for. What is going on? There's something wrong. It's not coincidence. There's something wrong, terribly wrong. Now, the last part, really, of the missing blood issue is thanoparatus. The issue arose about how much blood was in the blood vial. Now, if you recall from the testimony, the first thing that happened is that Mr. Yamauchi got the blood and he stuck in a pipetter that takes 1 ml, and he created the Fitzco card. So that's 1 ml. The next thing that happens, that's on June 14th. On June 21st, toxicology gets it. And toxicology does things in an appropriate way. They measured how much blood was in the tube. They take a tube, as Mr. Matheson described it, you fill it with water, you look at the other tube, and you make a measurement. And they measured it to be 5.5. Now, if it's 5.5, and we started with 8 cc's, and Yamauchi took 1, there's 1.5 missing. No way out of that. No way out of that. Now, Mr. Matheson came in, and you saw these incredible experiments that he was performing, where he went and he started taking, he looked at all the other times people went into the tubes, and he's saying, well, you know, if you pipette it out and you pipette it out, you may lose something over time. But let's face it, the Matheson explanations can't get around the 1.5 missing right away. There's 1.5 missing right away, and toxicology proves it, and they knew it. So the only other way to explain the missing blood is thanoparatus must have been mistaken. That's the only way. And what I'll leave you with this morning are 2 clips from thanoparatus. Technology willing.
How much blood did you withdraw from Mr. Simpson?
Approximately 8 cc's.
You say approximately, you did not measure the amount?
Well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and looked at about 8 cc's. I went through the needle from his arm.
And did you go through the same demonstration that you just showed for the camera today when I was the dispenser? That's all right. Now, there was another statement that I want to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Do you remember
a
that?
statement. Which I looked at it, I should have said it looked like it was enough, which it was enough. And 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after blood, or when the blood was being drawn? Mr. Simpson.
Syringe here. Okay, let's take it out. I pulled it out. I saw that. What it was, I squirted the blood into the trash. I just took the syringe back.
Okay,
I didn't turn it over.
there is a part.
Come back from lunch, we'll discuss the meaning of this. Thank you.
All right, ladies and gentlemen, we're going to take our break for the lunch recess. Please remember all my admonitions to you. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30. All right, thank you, counsel. And let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon again, ladies and gentlemen. And Mr. Scheck, you may continue with your argument, sir.
Thank you very much, Your Honor. Good afternoon, ladies and gentlemen of the jury. When we left, I showed you 2 clips from Thano Paratus. In the first clip, he was under oath. He said, when he drew Mr. Simpson's blood, he looked at the syringe. And that's how he knew it was between 7.9 and 8.1. No doubt about it. Something he does all the time, routine, something people in this field would do and know. He looked at the syringe. Then, because they couldn't live with it, because 1.5 is missing, and they could have called Thano Paratus in his direct case and put him under oath, Mr. Goldberg goes out and does this statement, this strange, bizarre statement in Mr. Paratus's home, which they tell you was unscripted, or that is to say, I mean, let's not say he gave him a script, but I mean, common sense tells you that they spoke to this man before they went and did this videotape, and you could tell at parts he literally said, I don't remember, because he was forgetting certain parts of what he, I guess, what it was planned to say. But let's get down to the substance. I mean, this is not under oath. It is the only testimony you've gotten in this case that is not under oath, which is fairly extraordinary. But you know what's even weirder? It's what he said. His position is this now. First of all, you can see the syringe, and you can see the calibrations on the syringe. So now he's saying, well, the syringe was turned over, and I didn't see the numbers. Well, that's pretty strange. But I think that what's even more odd is that it is his position that he now realized that he goofed. How does he know? He says that he took one of these tubes, now these, are items in evidence, and he looked at it. And he now remembers, months later, that when he drew Mr. Simpson's blood on June 13th, he can remember the level that the blood was in the vial. And based on his recollection of where the blood is in the vial, he then starts putting water in to another test tube to get it up to that level. And then he says, well, that's 6.5. Well, that's not worthy of belief, is it? That you can remember all these months later the exact level, and that's how you come up with 6.5? So not only is it not under oath, and not only is it obviously a convenient recantation, and appears to have been prepared, shall we say, to suit the prosecution's purposes when things just didn't fit. But the story is an absurdity. It is just an absurdity. It is not worthy of belief. It is a reasonable doubt in and of itself. Blood is missing.
Evidence items are those?
This was the syringe, which is 1382, and 1124, a purple top tube of exactly the kind involved in this matter. Could we have slide number 9? So let's review the bidding. Missing blood. Access opportunity and Mr. Paratus, the smoking gun. Detective Van Adder is walking around with this tube in a May 10th envelope, unsealed, going up for coffee, 3 hours. It is misnumbered. It comes in as 18, not 17, 18, after the sneakers, which were brought in the next morning. There is at least 1.5 mil missing, no question about it, early in the game because of the toxicology entry. And then we have Mr. Paratus's unsworn recantation. Is this a coincidence, or is it corroboration that something is wrong, something's terribly wrong at the heart of this case? It is a reasonable doubt, because missing blood, I submit to you, the blood is an essential fact in the prosecution's circumstantial case. If you can't trust the man who carried the blood, if you can't trust where this blood went, I mean, EDTA, missing blood. Coincidence? Corroboration. Something is terribly wrong. Now I'd like to move to the blood drops found at Bundy. And there are two aspects of examining this evidence. The first has to go to the integrity of the samples, and the second one goes to the issue of cross-contamination. First, I would like to address the issue of the integrity of the samples. We start with the handling of the swatches. And we know that they are not counted at the scene. They are not counted when they get back to the lab and put into test tubes for drying. They are not counted the next morning when they're taken out of those tubes. There's no count. First time there's a count is when Yamauchi gets it between 9 and 11:20 that morning, June 14th. So we don't know how many swatches we started with originally. And as Dr. Lee told you, as all criminalists told you, as Gary Sims told you, it is the first duty of a forensic scientist to document the evidence and to establish a chain of custody that preserves the integrity of the evidence so that you can bring it into court and good people like you can feel satisfied that you have honest, reliable evidence. That was not done. No booking until June 16th. It's in the lowest security area, that evidence processing room where that metal gate can be lifted, where yes, you have to have a card to get into the door, but other people walk in and out and the entries are not monitored. It is an unlocked cabinet, and in this phase, there is no way to trace the individual items. Now, we had asked, Your Honor, for the bindles to be produced, but they have not been produced. But you can get them. You can get them when you go back into the jury room. And there is one absolutely extraordinary fact in this case. On August 23rd, Andrea Mazzola was called to testify at a hearing in this court, put her hand on the Bible, swore to tell the truth. When she came in, she had her notes, the same crime scene log notes that she and Mr. Fung had reviewed in their testimony. She got on the stand And she was asked questions by Mr. Neufeld about how they went about collecting the swatches and the evidence in this case. And she described the process of taking up the swatches, coming back to the lab, putting them in the tubes for drying, taking them out the next morning, putting them into bindles, and then she testified that they initialed the bindles, that she, Andrea Mazzola, took some of them, Mr. Fung took others of them, and she initialed the bindles, those little white bindles that the swatches were in. You all recall that. She said that under oath on August 23rd. And, you know, think about whether or not she would have good reason to remember and have a best recollection of what actually occurred when she testified on August 23rd. This case was the first crime scene that Andrea Mazzola had ever primary responsibility for collecting blood evidence. A good reason to remember. Between June 13th and August 23rd, when she testified under oath, Andrea Mazzola had not done another crime scene. So there was nothing to confuse her. Collected blood from a crime scene. When she testified, she knew that this was an important matter. I realized that she did not know who Mr. OJ Simpson was, fair enough, but she certainly knew that this was an important matter and that everybody was concerned about it, and you would expect that she would want to testify in a fashion, to the best of her recollection, looking at those notes. She said, no question about it, that she initialed the bindles. You will get the bindles. We laid them out for you. You can look at 52, 50, 49, 48, 47. Her initials are on no bindles. Zero. Something is wrong. We have the board. Dr. Henry Lee is quite a remarkable man. And we tracked this evidence. His offer was not taken up, he and Dr. Batten, to examine this evidence. At the time it was collected, as the testing was going on, he did not really get a chance to examine and handle the evidence until February 16th, while you're still sitting here. However, we did try to track it as much as possible, and we were allowed to take pictures at the Cellmark laboratory of the swatches, and we were allowed to take pictures of the bindles and measure them and weigh them because something was wrong. And then we found the wet transfers. This is very disturbing, as Dr. Lee indicates, because the uncontradicted testimony is that these swatches were put in test tubes to dry for 14 hours. And Dr. Lee gave you his best estimate that he thought they would dry within 3. And then Mr. Goldberg came in with, you have that study? The Epstein-Barr study, and if we go to cotton cloth, indicates that it should take about 55 minutes, if you look at it, under condition number 1, that's at room temperature, to dry. So no. They should have been dry. I expect they'll come in and they'll say, well, there was a swatch sandwich, they were all stuck together so they wouldn't dry. Nonsense. Use your common sense. How do you get wet transfers like this? Well, within 3 hours of the time that they were taken out and put in bindles, if somebody had switched swatches, you'd see wet transfer. Now, there was a very interesting point in this trial where Mr. Matheson was asked some questions about knowledge that detectives had with respect to the collection of blood evidence. And he and both Mr. Fung testified to this, that detectives are trained in the collection of blood evidence in exactly the way that they do it at LAPD. Now, remember, the way they do it at LAPD is not the way one should do it for the collection of samples for purposes of DNA evidence. They haven't changed their procedures, as was testified by Ms. Kessler, the head of the lab, in terms of, old conventional serology testing. So they're still putting them in plastic bags and degrading samples. But put that aside for a second. Matheson is asked, starting at 25031 of the transcript, about question, when you say evidence collection technique, have you ever taught detectives how to collect a stain using LAPD procedures? Talking about a biological stain, yes. And he goes on to talk about how they want detectives to have the capability to collect blood drops, and they have an on-call system, and sometimes a criminalist, is not available, so they want detectives to swatch blood stains. And he goes on to say, and I quote, "We supply them with blood collection kits. Simply a file box with the tools that are necessary to collect the samples." We're talking here plastic bags and swatches and gloves. And question, I know they are taught how to, take a control and use the distilled water and use the tweezers, the whole 9 yards? Answer, yes. They are both shown in a demonstration form. We talk to them about it. It is demonstrated to them, and if time permits, we have practiced with them within class. Question, and are detectives in fact collecting biological evidence in the Los Angeles Police Department and submitting it to your laboratory for analysis? Yes, they do. Detectives have swatches. These detectives would put them in plastic bags just like Fung and Yamauchi if they were to be stored for some period of time. It would degrade them. Even if they put swatches with EDTA blood on them, they still degrade them. These ridiculous techniques, if they were put into those envelopes and left wet transfers, the integrity of the evidence is in question. Something wrong. Admittedly, to be fair to the prosecution, there's probably not enough sample left from the Bundy blood drops to take them out for EDTA testing. But they didn't do it. And I think you have to ask yourself a fair question, given the way the blood evidence has been handled in this case. What would those results be? Just from this, you must question. Must have a reasonable doubt about the integrity of this evidence. But when you consider the evidence, we have to take the evidence as it is, and we have to reconstruct as best we can what's going on in the case, as you must, in a fair and unbiased way. And you consider the evidence, the whole issue of contamination arises. And it arises in a funny way, because one can see that if these samples had been contaminated, cross-contaminated in a way that I know you have followed, and I will review with you, and forgive me if I repeat details that I'm sure you have followed, that certainly would convince certain people that they were on the right track, and maybe they wouldn't hesitate to tamper with other evidence after that to make the case look better. Could cross-contamination have happened on these facts? Before I go into detail, I'd like to make 2 points. Same point I think I made at the beginning, Dr. Speed made. If there was cross-contamination in the evidence processing room on the morning of June 14th, when Mr. Yamauchi was handling the samples and Mr. Simpson's reference samples at the same time, or on June 13th to June 14th when Fung and Mazzola were handling these swatches, it wouldn't matter how many times you tested them after that, they'd all come back the same. So let's focus on what the issue is. It's what Dr. Speed was calling common mode error. In fact, if we could put this flow chart on the... Remember, the prosecution showed Dr. Speed a flow chart. It's a little hard to see there, but Mr. Harris, if you could circle the evidence processing room. This was the final flow chart. There are 2 little houses that represent the evidence processing room. That's drying on June 13th at the bottom and sampling on 6/14. And as you see, in terms of the testing, now do both. Please circle both. This is an item in evidence. The circling won't be in evidence, although I was looking for it. I could have sworn Dr. Speed had circled one, but I couldn't find the exhibit. In terms of the workflow, that's where cross-contamination, contamination occurred in the way they handled these swatches on June 13th and June 14th. And if it happens there, it doesn't matter who else tests it or how many times, you can't validate it. Because if the DNA was cross-contaminated there, it's going to come out the same every time. Now, thank you. That's point number one. Point number two is the presumption of regularity. You heard that the primary answer that Gary Sims and Robin Cotton were giving on why they distrusted the explanation of cross-contamination is they said, we must assume that substrate controls were handled in parallel with the other evidence items. Now, there's a lot of problems with making that assumption. Number one, we know that Fung and Mazzola have no training in terms of why the substrate controls should be handled in parallel. In other words, if they handled all the wet red swatches first and then they did the controls after, they didn't put them in precise order, then it no longer serves as a control against cross-contamination. So they're saying we must assume that they were handled in parallel. And if we make that assumption, then we think controls worked. Well, there can be no presumption of regularity at the LAPD on how they handle these swatches. And the reason that they are not entitled to that presumption, and there's number one, Mr. Simpson is entitled to the presumption of innocence, but number two, we have proven that they're not entitled to it. Dr. Gerdes has proven it. Dr. Gerdes came in and he did an extensive study of the LAPD lab. Let me get rid of that circle. And I won't review all of what he said, but I think it's a fair assessment of this man's testimony. It is a solid, straightforward, careful scientist who spent hundreds of hours reviewing data, doing an inspection. And what he found is that there was a cesspool of contamination in this laboratory. No mistake about it. Cesspool of contamination. The second thing that he proved, and you get that cesspool, how can you just assume they're doing everything right when we can prove they're doing everything wrong? Next clip. The next part of his testimony that has particular relevance is the whole issue of contamination by control. If you recall, when he examined the controls, there were controls that would show that there was contamination going on at the extraction process, that is, in the evidence handling, the EPR, the evidence processing room stage, as opposed to later when the amplification occurs, or the so-called negative amplification control. And based on this data, he made the assessment that the contamination problem at LAPD is happening in that evidence processing room stage when they're handling the samples. Thank you. So we have proven that they are not entitled to any assumption of regularity in that evidence processing room in the way they handle the samples, because they are getting this contamination all the time. Dr. Gerdes' testimony, I think, also proves something significant in this regard. He proved that they literally don't know what they're doing. It's a shame. They do a validation study where they're processing known samples and things like cases, and they give a report saying there are no incorrect typable results observed. And that's simply not true. And I know we went back and forth about the errors that they made, but you recall the testimony. Some of the errors they made on their own validation study, Mr. Yamauchi and the others, were of the kind that could create false positives that could convict innocent people. And they didn't even note in their own review of it that they made those errors. If they're saying they could be justified, then they should have at the least said there were some incorrect results observed, but these are the reasons. But they didn't even do that because they weren't even aware of it. Mr. Matheson, who admits no DNA expertise of any significance, is the one reviewing it. He didn't notice anything wrong. Dr. Gerdes, without going into too much, talked about how they don't change their reagents in a regular way like they do at DOJ or Cellmark or any other self-respecting laboratory. They didn't even realize that they had this contamination problem, which is even more frightening. And you did not see a witness come in to rebut Dr. Gerdes. One would have assumed that an independent scientist not associated with a laboratory would have come in here to refute his data. And they'll talk about, well, you didn't call Dr. Mullis, you know, that person would have come in. Dr. Mullis could have been a surrebuttal witness. It didn't happen. I'm kind of surprised, frankly. Now, they're going to say that, or have said, what have they said about Dr. Gerdes so far? He was paid money. He's not a forensic scientist. He's not qualified to review a DNA laboratory. Well, I think you're going to reject that for good reasons. He's reviewed 23 forensic laboratories, the work of them. He's visited 7 laboratories. He plainly knows the literature in this field. He demonstrated that on cross-examination by a very fine lawyer. Couldn't ask him one question about an article he hadn't read or assessed. He is a microbiologist, which is particularly important training. I'm sure some of you know that from your own work. And that is a person who is a student of how contamination occurs, bacterial contamination occurs, clean methods, sterile methods. He has a PhD in this field from UCLA. This man, his lab is accredited by a number of organizations in paternity testing, disease diagnosis, organ transplants, bone marrow transplants, many organizations inspected, accredited his laboratory. He understands these procedures. This man deals with life and death every day, with DNA testing. The nerve of them to say, you're not a forensic scientist. You can't assess a DNA laboratory and how they handle the samples there. That's audacious. That is not worthy of your consideration as an answer. Put on a witness, show data, get a self-respecting scientist to come in here and refute what Dr. Gerdes said. They couldn't do it, they wouldn't do it, they can't do it, and that's why you heard no one. Because he's right. And the lab, I mean, it's terrible. You can see. They were training each other, Yamauchi and Aaron Riley. They had no PhD brought in to construct this place. That's not right. That's not right. You're citizens here. We're entitled to more than that. You can't run a lab like this. You can't then get up here in closing argument and go, we have a sloppy lab. We're dealing with life and death. Just like these transplants, we're dealing with life and death. It's too late to say now, ignore all this. You can't. Now, they're going to say, he's doing it by medical standards. That's too high. Can't judge a forensic lab by the standards we used for medical DNA. But we went through this, and we know, frankly, that forensics is more challenging. In medical applications, known samples, clean samples, unlimited amounts, they're not degraded. All that occurs in the forensic situation. There's no justification for saying the standard should be lower. And even under a forensic standard, whatever that might be, and frankly, these are the standards, and you know they're not coming close to this book. Even by those standards, Dr. Gerdes offered a conclusion which I think is not unreasonable in the evidence and stands unrefuted. It should have been shut down. And that's what they're asking you to accept. But it goes further. You know, Ms. Clark said, and I frankly think, I assume she's going to be answering all this in rebuttal, it is not, after all we went through with this DNA evidence, it is not enough to say to you, because you know a lot about this now, to say, oh, they're saying something about flying DNA cause cross-contamination. Flying DNA. That is not the contention. The contention is specific. It is in the evidence processing room. It is in the way these samples were handled. It is in the kind of lab they deal with. You have the next slide, please. No. We know, and I know you know what this is about. When you take the swatches and you put them in plastic bags and you cook them for 7 hours, you degrade the DNA. And as we went through it, Dr. Cotton admitted it, Gary Sims admitted, everybody admits it. It's fundamental. You can degrade the DNA so that there's none left that is detectable. And if you cross-contaminate it with another sample from a reference tube from high-concentration DNA, and remember, we're not talking about very much. The highest amount here is an RFLP test by Cellmark of 25 nanograms, and you know, because we've been through this, that is, you know, such a small amount, less than a drop, a very small speck can create 25 nanograms of high molecular weight DNA. You know that now. I bet you before you came into this jury, you wouldn't have ever thought that you would be literate in this, but you are. You know this now. Okay, next. No, that's not it. Now, there's an issue of risk factors. And you have to assess what was handled here in terms of what is an acceptable or an unacceptable level of risk. Now, you remember all these logos. And I won't go through all of them, but handling multiple swatches in a hurry, handling samples from both crime scenes at the same time, not changing gloves, not routinely between samples, not changing paper and washing down between samples. When you scrape the swatches out of the tubes, creating aerosols, all these things create risks of cross-contamination. All these things, Gary Sims told you, their witness, were wrong. But the single worst thing that was done, the cardinal rule of handling these samples in a DNA lab, is the one in the upper right-hand corner. And that is handling Mr. Simpson's reference tube at the same time that you are processing the swatches and the glove. That is the biggest no-no that forensic labs have learned from bitter experience, as we'll discuss in a minute. What happened in the evidence processing room that morning? We know that Mr. Yamauchi says he got the sample at about 9 from Mr. Fung. And on cross-examination, he said something that was really remarkable. Do you recall this? All of a sudden, he said, I remember now. I opened up the tube, and the blood spurted up through the chem wipe, and it got on my gloves. Now, he was a little vague about what he did with the gloves. He doesn't remember whether he put them in a biohazard bag right in the evidence processing room or went to the serology lab and got rid of them there. But all of a sudden, we now know there was a spillage of blood there. Now, that is extraordinarily significant because there's plenty of high molecular weight DNA in the smallest drop if you get it on your gloves or if you don't change the gloves. And frankly, I think there's no reason to believe he did, to contaminate these samples that we know are degraded. And it's so easy to do that and not be aware of it. And it's so easy to do that when you're in a hurry. And it's so easy to do that when you're only out of training for 6 months and you're in a tough position. And it's so easy to do that and not really be aware of it. So easy to make that kind of mistake when you really haven't had the training. So easy to do it when you're handling 21 samples that morning in one day, something that an experienced technician like Gary Sims tells you it takes days to do. So easy to make that mistake and cross-contaminate these samples. So easy. What's most important is that there's an unacceptable level of risk. You cannot accept this presumption that it all went right beyond a reasonable doubt. There's no way. Now, interestingly, when he says, even by his testimony, that he opened up the tube, the blood spurted out, let's give him changing the gloves, although there's no real reason to accept that, frankly. There's still, by his own admission, going to be blood on that table. Blood that you can swipe with your gloves or your hands, and it doesn't take much to do this transfer. He didn't wash down that table. There was no paper there that he changed. There's blood on the table. A fair inference. Now, The next thing that Ms. Clark said, and I don't know if she was listening to the evidence that carefully in this phase of the case, to be frank, is she said, well, if there were contamination, if there were DNA flying around from Mr. Simpson's sample, then we would have seen proof somewhere else that his blood had contaminated other samples. That's what we would have seen. Well, there was. On June 15th, if you recall, a second set of samples was handled by Mr. Yamauchi. He had the reference tube from Nicole Brown Simpson, the reference tube from Ronald Goldman, and he had item number 12, which were the 3 blood drops picked up at the foyer in Mr. Simpson's residence. Those were the last drops picked up that day. They were the ones that were last put in a plastic bag, and Gary Sims has told us those are the ones that had the highest DNA concentration of any of the samples. Item number 12. They are the one that got an RFLP result from Cellmark. So we know that item number 12 is high concentration DNA. We know that item number 12 was being handled by Mr. Yamauchi on June 15th with the reference samples of Goldman and Nicole, which are also high concentration samples. And Dr. Gertie showed you how at LAPD, and then on the polymarkers at Cellmark, and then at DOJ, we got typings that were consistent with cross-contamination from item number 12. And all the controls on those second days, those negative controls, are clean. Because, as I'll discuss in a second, we've already proven these things happen with negative controls being clean. You get this cross-contamination. So, this was proof that Mr. Simpson's DNA, by sloppy handling, was cross-contaminated and typed lab after lab. And you heard that on cross-examination, Mr. Clark didn't even confront Dr. Gerties with this board. And you know what? He's a fine lawyer, and he knows this subject matter well. He didn't cross him on it because they can't touch it. In order for this to be true, the only thing they can say is, well, there was an extraordinary series of artifacts that accounted for some of it, but it didn't account for this polymarker typing. That can't be an artifact. It's proven. Thank you. And not refuted. And I should say one more thing in passing I forgot to mention, that when Dr. Gertie showed you his study of contamination at LAPD, when you have these negative controls, you can have contamination and the negative controls come up clean. In fact, in the instances where he saw contamination, 26% of the time, the negative controls were clean. And there's reasons for that, because these negative controls are not always going to pick stuff up. And you saw it right here. There's proof. Now, there's one other point to be made about this issue of cross-contamination at the LAPD. In that evidence processing room, we can't be any more specific about it. It's no flying DNA. And that is, you have to have an appreciation of how mistakes can happen with this technology. And we learned something about that from Dr. Robin Cotton. If you recall, the California Association of Crime Lab Directors gave a proficiency test where they used degraded samples in 1989. And in this test, they gave samples to Cellmark and to other labs, and there were false positives. And Cellmark got 2 false positives, the first and the second time. And you remember what Dr. Cotton told you about what they learned of that? When they did these tests, the second one in particular, the way that they got a false positive through cross-contamination is that they had a degraded sample. And the CACA study is the only one where they really are sending these labs degraded samples, just like here. There's a degraded sample, because that creates a risk of cross-contamination when you degrade out the initial DNA. And the only thing, do you recall this? The only thing they could isolate is that they were handling the reference sample at the same time they were handling the degraded sample. And what was interesting about her testimony is she testified that they had a witness in the room. In other words, when they were doing these proficiency tests, they were witnessed. Each transfer was witnessed by somebody standing right there. And all they could reconstruct at the end was that they had made a mistake This discussion started at 27517. Mr. Neufeld was asking, and you determined that it happened at some point during the extraction process. Yes, in dealing with the sperm fractions. But even to this day, Dr. Cotton, would it be fair to say you don't know how the accidental contamination occurred during the extraction process? Yes, that would be fair to say. Question, and it would also be fair to say that this cross-contamination, this accidental cross-contamination happened in spite of the fact that all of the sample transfers were witnessed by a second person to make sure no errors occurred. Answer, you are exactly right. Now, just think of the analogy. This is 1989. Actually, the second one also happened in 1990. This is when Cellmark was starting out. And even when they started out, they had far more qualified personnel than anybody that came in here from the LAPD. And they got a degraded sample, and they handled the reference sample at the same time, and they still can't figure it out, but that's when the cross-contamination occurred. So it happens. And it happened to a much better lab than LAPD, and it happened when they were just beginning. Just the way LAPD is just beginning here with far less trained personnel, frankly. So don't come in and tell us, based on this evidence, that it's unreasonable to suggest that there was cross-contamination, because all the evidence really, all the rational inferences point in that direction, that there was an unacceptable risk of it, and we have proof that it was going on with those samples from June 15th. Now, this leads me to a discussion briefly of numbers. We saw a lot of numbers in this case, and one of those numbers, as the judge has instructed you, is what I guess is being called the random match probability. That is, what are the odds that somebody coincidentally has the same DNA pattern that they may find in some sample? And some of these numbers are pretty staggering. These are just frequencies, you know, 1 in the billion, 1 in the trillion. Now, there are, frankly, some problems with these numbers. Dr. Weir, who came in here and testified that he's absolutely 100% right, and these people are just wrong, then offered you numbers which he had to admit were wrong and inflated and biased against the defendant. And Dr. Cotton, using Dr. Weir's methods, has come in here and told you that the database for a 5-probe match at Cellmark for an African American is based on samples they got from Detroit, and in terms of how many people have been tested on all 5 probes, and you get down to it, it's a group of people from Detroit and just 2 of them. So there are some problems with these numbers, but let's put them aside, because they're really, in a sense, irrelevant to the main issues in this case. There's problems with them, and I don't think that you can just accept them at face value, but to find many reasonable doubts, they're really irrelevant. And the reason is that the issues in this case, as I'm sure you've realized, are how did blood get on these samples in the first place? Who put it there? Did they get there through contamination? Was there laboratory error? Was there corruption, contamination of these samples? That's the issue. So the numbers really are irrelevant. They're just telling you frequencies about samples, but it doesn't answer the question, how'd the blood get there? Now, the judge has told you that laboratory error and these random match probabilities are different phenomena. They are. They're different things. And you know that from your own common sense. Let me give you a simple analogy. Let's say that we're trying to figure out the odds of somebody getting killed when they're walking across the street. There's lots of different ways that can happen. you could get struck by lightning. And the odds of that happening are probably like some of these random match probabilities, 1 in a trillion. On the other hand, if you're walking down the street, across the street, and it's a busy thoroughfare, and you walk out in the middle of traffic, the odds are greater you'll get hit and killed. If the cars are moving at 60 miles an hour, 70 miles an hour, the odds increase. If you walk out in the middle of the block, the odds are getting greater. If you're walking against the light, the odds are getting greater. The chances can be almost certain that you're making a mistake. So what you have to look at in assessing laboratory error are risk factors. And we know that the risk factors in the evidence processing room are unacceptably high, as Dr. Gerdes told you, unacceptably high. So if we could review. Are the Bundy blood drops cross-contaminated? We have to look at the history of this lab, a cesspool of contamination, unrefuted. The contamination, as Dr. Gerdes says, is localized in the evidence handling, exactly where it looks like it happened in this case. The risk factors in that evidence processing room are unacceptably high. We have contamination from that reference sample board on June 15th of Mr. Simpson's blood going into 2 reference samples with the controls being clean. And then we have the whole issue of Mr. Yamauchi spilling the blood. It's reasonable doubt. Now I'd like to turn briefly to the hair and fiber evidence. You heard from, Ms. Clark can say it's his hair or it's this fiber. But as she had to say in her closing, that is not what the testimony was from the witness, because hair and fiber evidence, as Mr. Diedrich pointed out, and as we all know, and as Dr. Lee pointed out, is what they call weak association evidence. It ain't DNA. It is weak association. We're talking about broad similarities. You can't even say the word match when you're talking about this evidence. It is really evidence by way of exclusion. We have to, they can't come up with a number and say this hair is, the odds of this being someone else's hair is 1 in 20. Can't even say that. It's just a question of looking at as many similar hairs to see if you can get an exclusion from a particular race. So there's no database, there's no number, it's just similarities. It is weak association evidence. Nobody is telling you that this is definitely somebody's hair is some particular fiber. Therefore, what you have to do with this kind of evidence, as Diedrich and Dr. Lee mentioned, is that you have to exclude other frequent visitors, for example, African-American visitors to the Bundy condo area, if you're doing a serious assessment of whose hair, man or woman, older children of Mr. Simpson, younger children of Mr. Simpson, others who were there could be contributors of the hair. Fiber is no different. The same general class characteristics. A big deal is being made about blue-black fiber from some unknown source that's found on 3 objects and maybe more. Now we have Mr. Diedrich talking about the blue-black fiber at 35338, line 12 to 17. Question: do you remember what you told us in your direct examination about the amount of cotton fiber that is manufactured in the United States every year? Answer: 5 billion pounds. Question: okay, do you have any idea whatsoever of the number of fabrics of blue-black nature that looked black to the naked eye and were distributed in the Los Angeles area in the past 5 or 10 years? Answer: I have no idea. You want to say 10%? What's 10% of 5 billion? Look around the courtroom. How many people are wearing blue-black cotton fibers? Maybe some of you, right now. So you have to look, when you're assessing this evidence, at background. Who could be contributing these hairs and fibers? And you can't say anything certain at all about the similarities. It's weak association evidence. We know that Mr. Simpson is a frequent visitor to the condo area. You would expect to find his hairs around there. you would expect to find Bronco fibers around there, not just from Mr. Simpson, but from Nicole Brown Simpson, from the children, from others who were in and out of that Bronco that's used as a utility vehicle. Just as a simple illustration, Dr. Lee, this is a soil exemplar that the LAPD took. They never made an assessment of the fibers. Here's hair and fiber that you just see in the soil from that closed-in area. It's okay. It's around everywhere. We shed them. It comes out. It's all around an area where people live. Now, one interesting character that could be a source of all these is Cato the dog. After all, Cato the dog is probably, in that closed-in dirt area, one of the most frequent visitors. And Cato the dog is carrying hairs from all the significant members of the family, and he's carrying Bronco fibers with him because he's a dog that shed. I had a sheepdog. You all have dogs. You know that that is a phenomenon. And Cato the dog, as we'll see, and it's a significant point, was at the crime scene that night. In terms of assessing hair and fiber evidence, you have to look at the issue of contamination, particularly when you're talking about hair and fiber flying all over the place at a crime scene. I mean, this is where the issue of contaminating a scene is of critical importance. And how did they handle this scene? We have the issue of the blanket. I mean, this, as Mr. Fung admitted, was colossal stupidity. To take a blanket that people, that Mr. Simpson and others with Bronco fibers, hairs from all kinds of African Americans on that blanket, and then throw it out over the crime scene, over the bodies, over the evidence items, everywhere, is asking for trouble. But perhaps the most significant problem here, and it's the one they haven't come clean on in this case at all, is dragging around the bodies. This was, in terms of handling a crime scene, this was really an incredible thing. Because if you're trying to make associations about hair and fiber evidence from clothing of the two victims and what might have been in the dirt area, where people are shedding these things all, and you drag the bodies all over the place, over the evidence that you're testing, there's no integrity to that. It's ludicrous. And nobody ever came clean and said who it was that moved those bodies through the envelope and the hat. And we all know that happened, right? They have to admit it happened. When they pulled Mr. Goldman's body through, or Lord knows what was going on, it was all moved and replaced, and nobody's ever come back and told you who put the envelope back in a different position, who put the hat back in a different position, who put the glove back. Nobody's ever come in and told you. And they certainly didn't investigate. We'll talk about that a little bit more. But we put in concrete evidence that this kind of cross-contamination was going on in the hair and fiber evidence. Could we have the next slide? These were slides that were put in evidence by Mr. Blazier, if you recall. And this represented something really interesting. It had to do with blood stains, blood evidence that you found on the clothes, the dress of Nicole Brown Simpson on the left, and the shirt and the jeans of Mr. Goldman on the right. And if you recall, there was not only blood evidence, stains on the bodies themselves, but there was also in the area where they were taking controls. You know, you try to find an area where there's no blood stain, you take a control, and those controls came up showing evidence of Nicole's blood on Ron's shirt, vice versa. Could we have the next slide? What is the exhibit number? I'll get you that. These are in evidence. The summary of the results were, on those clothings, go back, please. Summary of the results, there were 23 stains tested. 16 of those stains showed carryover. And very interestingly, if Mr. Simpson supposedly committed these murders and his hand was cut and he's struggling here, no matches, no evidence of his blood on this clothing. But there is carryover between the clothing. Now, what does that mean? That means, frankly, that the bodies were dragged through the crime scene, and blood from Nicole Brown Simpson got on Mr. Goldman and vice versa. And if that happens, That's how the fibers can get carried over too. And Ms. Clark went on, and I think she even put some, little pieces of the puzzle up there. She went on with this rank speculation where she was saying, well, we know that it was one killer. And we know it was one killer because we saw some fibers that came from Nicole's dress and got on Ron's shirt or jeans and then back and forth. And that's how we know that one person was going back and forth between two victims. Nonsense. This proves it. This proves that the hair and fiber and the blood evidence were all coming together because the handling of this crime scene is a disgrace. A disgrace. They're dragging the bodies back and forth. Okay. Now, also, it should be noted that it came out during the testimony of Ms. Brockbank that the two gloves and the two hats, the knit hat and the plaid hat found in Mr. Simpson's Bronco, and the Bronco carpet that was cut out of the car, were all placed in the same box. I mean, the way they handle this stuff, and then they want to come in and say there's integrity to the hair and fiber evidence, is ridiculous. Briefly on the hat, we had testimony about dandruff. You heard Mr. Simpson's barber say that in the off-season, in the summer, in spring, he gets dandruff. Right after he's arrested, they remove known hair samples. His hair has dandruff. There's no dandruff in the hair in that hat. Now, if we look at the hair and fiber evidence as a whole, there are, and this is just weak association evidence, nonetheless, there are powerful inferences consistent with innocence. And these were put on slides that are in evidence. I'd like to review them briefly with you. Both gloves. No hair consistent with Mr. Simpson on the Bundy glove. No hair consistent with Mr. Simpson on the Rockingham glove. That's the slide we put up. But you know what we should have added to that slide? Very significant facts that I hope you don't forget. There was an unidentified Caucasian hair on the Rockingham glove. Did they test Mark Furman? Did we get a hair exemplar from him? Also, and this is a fascinating point, Cato the dog, his hair was found on the Rockingham glove. And I'd like you to read this testimony to you because I don't think it was an answer that Ms. Clark particularly liked. And this was in the cross-examination of Mr. Diedrich. Question. And they were talking about Cato's hair, and page 34949 of the transcript. Is the finding of such hairs, Cato hairs, on the Rockingham glove accounted for by possible contact between the wearer of that glove, the murderer, and Cato the dog, either during or immediately after the murders? Answer, could have. It could have been a direct transfer for the dog, or as I stated before, an indirect transfer from hairs at the crime scene. Question, that were, say, where? Answer, on the ground maybe. Would have to have been on the ground. Question, have to have been on the ground? Answer, or perhaps from one of the victims who had been on the ground and collected the hairs. Question, and that you have previously described those as being common to the under part of a dog as opposed to the tuft or the coat. Now he's talking about the hair. This was a soft hair from Cato the dog found on the Rockingham glove. Answer, okay. It may be just a matter of semantics here. When I say the under part, under the fur, under the out of coat, which could have been on the belly, it could have been on the back, but it is just the soft, fine hairs that are closer to the body. Question, if that dog used this shaded place to sleep or lie down on a regular basis when it was in the Bundy residence, might you expect to find some fur hairs left behind in the soil? Answer, I would expect that, yes. Question, and if the Rockingham glove were deposited any time on that soil, the Rockingham glove being on the Bundy soil in the closed-in area, were deposited any time on that soil, might that not explain the presence of those hairs? Answer, it could, yes. So very simply, he's saying that this is hair from the soft underbelly of Cato of the dog, the kind that you would expect to be shed if he were lying on the ground there, not the kind that you get if the dog sort of pats you, all right, or it comes up on you as they're going to probably claim, fleeing the crime scene or something. It's a soft hair. It's the kind that you would find on the ground in the closed-in area. What does that mean? That means that Rockingham glove started at Bundy. Somebody took it somewhere else. And you know who that was. Let's go on to the next slide. The socks. There's no fiber on the socks consistent with either glove, and these are cashmere gloves where cashmere would easily come out and get on your hands, transfer to the socks. No fiber consistent with Mr. Goldman's clothes, and we know there was hand-to-hand combat here. No fiber consistent with Nicole Brown Simpson's clothes. Nothing on those socks. Also, we should add, no soil on those socks, no trace, no berries, nothing. Pretty interesting, those socks. Next one, please. As far as the hair is concerned, no hair from Mr. Goldman, no hair from Nicole Brown Simpson on those socks. Next, please. As far as Bronco fiber is concerned, no Bronco fiber is found on either glove. No no fiber consistent with Mr. Goldman's clothes is found. No fiber consistent with Nicole Brown Simpson's clothes is found. Next. As far as hair, no hair consistent with Miss Brown Simpson, no hair consistent with Mr. Goldman on the Bronco. Okay, and I should add, you know, in the Bronco, what they did is not only did they take out that carpet, but they went in and they vacuumed it. They vacuumed it to get all the hair and trace. They vacuumed it. And even Mr. Diedrich himself, when he was talking about hair transfer, said, well, the way it would get transferred is when you go, you sit down in your car, things would come off. There's nothing in the Bronco. How can that be? Now I'd like to move on to the crime scene at Bundy and evidence of struggle, the testimony of Dr. Baden and Dr. Lee. And I guess Dr. Lakshmanan, who came in here as the person for the prosecution to try to reconstruct that crime scene. You know, there are bloodstain experts and criminalists and people like Dr. Lee out there prosecution could have called to come in here and try to assess this evidence for you. They did not do so. They brought you Dr. Lakshmanan, working over section generation photographs, who was a coroner, to do only one part, or as best he could, with this evidence. Now, we know, as Ms. Clark indicated in her closing argument, that Nicole Brown Simpson did struggle before her death. And we know that there were defensive wounds on her hands. And we know that some of the wounds to her neck showed evidence of struggle. And then we have the fingernail scrapings. Now, Mr. Sims had said that he would expect that when you did fingernail scrapings, you would find, excuse me for just a second, he would expect that there would be skin under the nails. Now, he's a fine man and a fine forensic scientist. I have no quarrel with him, but he was admittedly testifying in an area outside of his expertise when he told you. He was saying that was his common sense understanding. But Dr. Baden came in and testified about what one ordinarily finds as a coroner with fingernail scrapings. Dr. Lakshmanan didn't dispute it, and that is that with fingernail scrapings, when you find it, you find blood under the nails, but you don't find skin, because when it grabs, the blood comes up, but the skin doesn't come with it. That's what Dr. Baden says you find. That's what the textbooks say you find when you get fingernail scrapings. So you would get blood, but not tissue. So let's explode that myth right away. But now we have the problem for the prosecution that when they do the fingernail scrapings, they come up on the EAP system with a B. That is not OJ Simpson's type. That is not Nicole Brown Simpson's type. That is not Mr. Goldman's type. It is some other person. And that's what their typing results showed. And so then it doesn't fit. It can't be right. So we have to see if we can make an assessment that would somehow undercut that finding. Now remember, when you have two conflicting reasonable interpretations of evidence, in a circumstantial evidence case, you have to go with the inference that's consistent with innocence. Now let's look at what happened. Mr. Matheson said, I think what could be here is that we had, can we show this slide? A four-banded BA from the Cole-Brown-Simpson that degrades into a two-banded B. Now, you recall this testimony, I'm sure, and the cross-examination by Mr. Blazier, and the testimony by Mr. Sims, who'd been doing serology a lot longer than Mr. Matheson, had a lot of experience in conventional serology. These are the facts. The facts are, in the literature, this supposed degradation pattern that Greg Matheson suggests could occur does not exist. There is no literature. Dr. George Sensabaugh, all the experts in this field, that doesn't happen. Nobody has seen it. Mr. Sims, who did more conventional serology than Mr. Matheson, said he, in his experience, has never seen a four-banded BA degrade into a two-banded B. Never. Mr. Matheson says he thinks he recalls somewhere he saw it. That ain't good enough. That kind of maybe I saw it, that ain't good enough. Maybe doesn't cut it in a criminal case. We're talking proof beyond a reasonable doubt. This is nonsense. Now, the other thing that they're trying to say is, all right, you can put aside the EAPB because there was DNA testing of some of that material under the nails, and that came back as 1.1, 1.1, Nicole Brown-Simpson's type. And they think that you're not going to understand this. But you do. Because, as you heard, the EAP system is a red blood cell. A red blood cell does not have a nucleus. There's no DNA on the red blood cell. The EAP typing system is something that looks at antigens on the outside of that red blood cell. So you can have blood under that nail, small amounts of blood under that nail, test out to an EAPB, and then when you get the little bed of epithelial cells under the nail, all right, or even some other things, blood that might have come in there from the Cole-Brown-Simpson, that can type out 1.1, 1.1. But the initial scrapings, when they ducked down, they came up with the EAPB. And you can't get around that. And you can't try to explain it away, and they don't bring in any serologists. Now, even Mr. Sims, and he's not a doctor, Mr. Sims, the best that he could do in looking at all of this, when they finally asked him the question on page 28748, he said, well, looking at all these findings, I can't exclude the possibility that the EAPB, or that might have been from the Cole-Brown system. I can't exclude the possibility. That is not exactly a firm statement. That is, again, a maybe. And a maybe doesn't cut it in a criminal case. And when you have two reasonable conflicting inferences, you've got to go with the one consistent with innocence. And that's what this evidence shows. That's fact. I'm not making any of this up. Those are facts. Okay? Now, sorry. No. Do you like
You want a glass of water? All right.
Sure. Something I said. Now, can we have the board? There's the whole issue of Mr. Goldman and his struggle with perpetrator or perpetrators. There were 30 stab wounds inflicted upon Mr. Goldman. Ms. Clark told you about, well, there were cuts on his hand, his open palms, sure. But what does that mean? If there are cuts on his hand and he is struggling with an assailant, it gets on the clothes of the assailant. Dr. Lee did an analysis of the scene based on the limited evidence that he could get, because they didn't document it in any way where you can do a good reconstruction, just a limited reconstruction. And we had multiple contacts, blood transfers in different areas of the closed-in area. And in each of these different areas where the multiple contacts occurred, as you recall, there were also vertical blood drops. And the fair inference from that evidence is that there's a struggle, people are up against one area, then another area, up against the other area, blood drops are going down. So there's struggle in different areas with an assailant or assailants. I mean, we can just reason from facts. We can't. Dr. Lakshmanan got up, and there's a whole hypothesis here that it all happened so quickly by surprise, stealth, surprise. I mean, you can't do that. You've got to look at facts. You've got to do a best analysis, a fair inference from the facts. And the facts show that there's multiple contacts in these different areas from the bloodstain evidence by the world's leading analyst of this, whose testimony on these points stand unrefuted. There is, of course, as we've discussed, the dugout area, particular struggle here, as even Detective Lang told you, where and other areas where there's signs of struggle between the assailant and Mr. Goldman, soil on the socks. There's contact by the way that they're banging against the sides of the gate, such that pants are going to come into contact with pants and shirt. Now, it's clear from the way this struggle went that some point early on, Mr. Goldman sustained this wound to his neck, and the blood began oozing down. And as Dr. Lee pointed out, he had to be standing, Dr. Baden, had to be standing vertical for some period of time because the blood did go down from his shirt all the way down his pants leg. And we saw blood, a lot of blood on the back of his pants. Now, if assailants are struggling together, there's going to be blood from the pants, blood from the shirt, in close contact, transferred to the assailant. Gotta be. It's a bloody struggle. And that's what this bloodstain evidence shows you. It's fair inferences from the facts. Now, the beeper and the keys. The significance, I submit to you, of the beeper and the keys at the very least, put aside keys as weapon, just the significance is thrown, you know, there's violence, tussling and struggling, the beeper is thrown down here. In the other area, another area of struggle, the keys are thrown down. If the keys are in the pocket, that's got to be a considerable tussle because for the keys to come out of the pocket in the other area. Or if the keys are in his hand, well, he's going to use that as a weapon. So you can't, you can't have it both ways. It shows multiple banging and struggling throughout that area. Now, the key fact that Ms. Clark conceded in her closing argument, key fact, is what Dr. Baden told you about the time between the wound in the neck and the time to the last fatal wound in the chest. And this is just fact. As Dr. Lee would say, there's scientific fact, there's interpretation. We deal with fact. The fact is that this wound had to come first, the one to the neck. There's blood oozing down. And the last wound is to the chest. When the wound in the chest occurred, as Dr. Baden told you, there's only 100 cc's of blood in the chest. What that must mean is that by the time Mr. Goldman was stabbed there, his heart was compromised. It wasn't beating very hard. So you did not have the amount, much more than 100 cc's of blood you would expect to find in the chest if it hadn't been the last, if not about the last wound. And Dr. Baden said, from the time just based on finding 100 cc's in the bleeding, a compromise of the heart, the time between the first stab and the last stab would be between at least 5 minutes, as much as 15 minutes, most reasonably 10. Now, that doesn't mean that the struggle went on from the first wound to the last wound for 10 minutes. What it means is, and this is what's crucial, that the assailant or assailants were there for that period of time. Could be that Mr. Goldman was subdued, was lying on the ground, and they did come and stab him last and make that last wound. But we know from the facts that between this wound and the wound to the chest, most reasonably 10 minutes. Somebody's there, at least some people are there for 10 minutes. Now, if the struggle occurs, starts 10:35, 10:40, based on scientific fact, Mr. Simpson can't be guilty of these crimes. Because he can't be two places at the same time, can he? Now, that time period is even, longer. They say, oh, take the 5 minutes. Give us, the prosecution, the inferences. Well, you can't. You can't. Because reasonable inferences, if it's between 5 and 15, most reasonably 10, you got to take 10. You can't give them the 5. That's not the way you can reason about a circumstantial evidence case. But even if you take the 5, something happened before that first wound, some period of time. So the window, the time here that these murders took is not this incredibly quick event that is necessary for the prosecution's timeline. And that's based on a reasonable, careful, scientific investigation of the evidence by Dr. Baden, one of the foremost pathologists, and Dr. Lee, one of the foremost forensic experts. This is evidence. Now, the next thing I'd like to point out has to do with the bloodstain imprints on the envelope. Oh, I'm sorry. I forgot this. Thank you very much. One other thing I should mention about the struggle. It's a critical point. I can't believe I left it out. How did...
Are there remains on the sport?
No. Where did this come from? Dr. Lee testified that it is a fresh cut. You can see when you examine the clean part of the top here, the interior, it is a fresh cut from a sharp instrument, consistent with a knife. Think about that. Think about that. What does that indicate about the nature of this struggle? Mr. Goldman, one or two assailants, somebody coming towards him, he kicked. Dr. Lee testified that by the angle that is consistent with the foot being raised in the air and a sharp instrument coming down, there's kicking. And if there's kicking, why are there no bruises on Mr. Simpson's body consistent with that kick? And why didn't anybody else come in here and point out this cut on the boot? Very significant evidence. And of course, there's the dirt on the boot that you would expect to see, and the blood on Mr. Goldman's jeans, and the broken buttons, indication of struggle there. Now, the bloodstain imprints on the envelope. Now, I know it's not Mr. Bodziak's area, but you have to consider all the evidence. And Dr. Lee, I think, gave us all a pretty sound education on bloodstain interpretation, enough to basically figure out and understand which blood stains, that certain deposits are made first, then other deposits are made over them. And I think that that's, pretty significant in terms of assessing this. Now, the first point that I think this goes to is, you recall Mr. Bodziak's testimony that there could only be one set of footprints leaving the scene. And when you analyze it, he concedes that that was based on the assumption that there was a pool of blood that all assailants would have to walk through. And I understand that he was not following all of Dr. Lee's testimony, only, I guess, 95% of it that dealt with footprints, but not the full 95% as I originally thought he was saying. But the point is, you know, it's like you forgot about Dr. Lakshmanan. Dr. Lakshmanan offered a scenario in broad respects that Dr. Baden said could well be the case, and it seems to be an operating premise here. And that is that Ms. Nicole Brown Simpson was subdued. She could have been hit on the head. It wouldn't necessarily knock her out, as Dr. Baden indicated, but might have incapacitated her or knocked her out. And then there's a struggle with Mr. Goldman, and then, or as a close to the final act, Ms. Nicole Brown Simpson's leaning over the stairwell, is inflicted with the last wound to her neck, and then the huge blood pool occurs. But if you're not necessarily, that is the assumption underlying Agent Bodziak's testimony, that if there were to be another set of footprints, it would have to be dark from a big pool of blood. It's not consistent with what Lakshmanan said. There could have been 1, 2 other people left that scene, somebody without leaving that tracks. They could have come out the way that the police did, which wouldn't leave imprints. Or there could have been partial imprints with small amounts of blood on the shoes that were not discovered because, frankly, they were not looking, as you can tell, very hard or very aggressively for anything other than focusing in on those Bruno Magli shoes. And I realize Agent Bodziak thinks very well of the photography of the criminalists at the LAPD, but taking good photographs of one Bruno Magli shoes does not mean that was combined with does not mean that they were looking for other imprints, as his book recommends that people do and do aggressively. Now, the one really interesting part of this envelope has to do with its handling. Do you recall Dr. Lee pointed out on the far right-hand corner that this is a mirror image stain, meaning that it had to be a wet deposit and then somebody folded the envelope. So the blood is wet and the envelope is folded. And then we see, could we have the next? This is what number, I'm sorry? 1348. 1348, as he focused in, is what appears to be consistent with a light transfer of a finger. Next. Next one. None. Blood making contact with the envelope. Now, this is a very interesting fact if you think about it, because Ms. Clark gave the hypothesis to you in her closing argument that Mr. Goldman was taken by surprise, dropped the envelope to the ground. So her theory is not that he kept that envelope in his hand as the struggle is continuing, or that he would make the bloody imprints on the envelope with his fingers. But somebody was interested in that envelope. Somebody appears to have opened up that envelope and created a bloody smear on the one lens we have remaining. Somebody made the mirror image fold on that envelope. Somebody was looking in it for some reason who had been in a struggle and left a bloody imprint of fingers. It's interesting, isn't it? And it is consistent with, well, it is inconsistent, certainly, with the prosecution's theory of Mr. Simpson committing these crimes, and consistent with others. Now, let's discuss the imprints. And the hour is getting late, and there's a lot to cover here, but let me just briefly go through that imprint evidence on the piece of paper, on the envelope, and on the jeans. And what Dr. Lee found on the walkway. And let's just piece it through, simple step by step. You'll go back, you'll look at the imprints on the jeans. And Agent Bodziak did not say that he had any expertise in imprints on fabric. And Agent Diedrich said this was the first time he'd ever done anything like this before. But I submit to you what Dr. Lee said about the imprints on the jeans is simply this. And I think if you look at those parallel line imprints, you'll see they could be consistent with kicking from a shoe. When they're bunched up, all right, there was some imprints, Dr. Lee said, is accordion effect. It's just the bunching of the jeans, but it's three-dimensional. You bunch up the jeans, an imprint occurs on it, and that's why some of those lines are not complete or completely parallel to that 3-inch heel print in particular that we went over with Agent Bodziak. It could be consistent with that kind of an imprint, but I really think it's inconsistent with. And Agent Diedrich sort of gave it away that he'd never done this kind of analysis before, is this parallel lines from Mr. Goldman's shirt, because they were talking about a swipe, and you all saw what a swipe is. Swipe leaves that smear. You can't swipe and leave those kinds of patterns like that on the jeans. It doesn't make any sense that there's this flailing and hitting of this fabric and it's going to create those kinds of imprints. It's more consistent with flat, hard surface hitting the three-dimensional folded up area. That's the jeans. Now, with respect to the piece of paper and the envelope, we can have a debate about whether or not, based on this evidence, there are imprints before there's a lot of blood on the scene, the early imprints. There's no border, but that's not necessarily inconsistent with it not being a shoe print. Parallel line imprint, Agent Bodziak didn't look very hard for these kind of parallel line imprints. Put that aside. Put that aside. Let's go with what they said. Agent Diedrich said, well, maybe that's from Mr. Goldman's jeans. And then he conceded that the most reasonable interpretation would be that Mr. Goldman fell once on the envelope area, if that's his jean imprint, and then again, or maybe once at the same time on the piece of paper out on the walkway. Well, that's not exactly consistent with the prosecution's theory about how these murders occurred, is it? So I don't think that gives them any real help here. And as to those shoe prints on the walkway that Dr. Lee discovered on June 25th, one is definitely a shoe print, no question about it. The other one, Agent Bodziak says, consistent with footwear. Well, they haven't eliminated the police or the photographer. It's just an example of what you could do. He got to the crime scene for 20 minutes and did the best he could under those circumstances. It is illustrative. It is not really explained, but you don't even need that when you consider the full scope of the evidence that two people could have done this crime on these facts is a fair inference. A lot of evidence to support that proposition.
Check, would this be a good time?
Sure.
All right. All right, ladies and gentlemen, we're going to take our mid-afternoon break at this time. Remember, all my admissions will be in recess for about 15 minutes. All right? Thank you. Record in the Simpson matter. All parties are again present. Deputy Trier, let's have the jurors, please. And let the record reflect we've now been rejoined by all the members of our jury panel. Good afternoon again, ladies and gentlemen. All right, Mr. Scheck is making his summation to the jury at this time, and Mr. Scheck, you may continue.
Thank you very much. I realize these have been long days, and I really appreciate your patience and the way that you followed. I was inaccurate in a statement I made to you, and I want to correct it immediately. That had to do with the hairs found on the Rockingham glove. Detective Furman, in checking the transcript at 34923, was in fact eliminated as the donor of that Caucasian hair, and that was an accuracy on my part. And any time, I've tried very hard to key everything to areas of the transcript, and if obviously, Ms. Clark, I'm sure will bring any inaccuracies to your attention. If there are any, try very hard to do that, and you should have the testimony reread. You shouldn't misread things like I just did. Another thing I forgot to mention about the Rockingham gloves, however, both gloves, and that is that they found a limb hair. Now, this Caucasian hair is not accounted for to anybody. But there is a limb hair that was found inside the glove. Now, if Mr. Simpson had had these gloves for 4 years, as the prosecution contends, then there should have been more limb hairs. One thing that you saw when you saw his hands, and that is that he has a lot of hair on this part of his fingers. And if these gloves have been worn for 4 years, you would expect to find a lot more of this limb hair inside the gloves. But you don't find that. So that's another point to consider that I left out. One quick point here on, do you remember Ms. Clark talked about a blood drop that landed on Mr. Goldman's boot, number 78, that on RFLP testing turned out to be a mixture of Nicole Brown Simpson and Ronald Goldman. And Detective Lang had offered a theory to you that this mixture could have occurred because one knife had committed both of these acts, and there was a combination or a mixture on the knife, and the blood drop fell and hit Mr. Goldman's boot there. Now, the first point to be made about that is the photograph you were shown was Mr. Goldman's boot being lifted up at the time that his body was taken over into the walkway and the coroners were taking pictures of it. If you look back at the photographs and you see the way his shoe was configured, it would be extremely unlikely that one drop of blood could hit because the shoe is at an angle. You couldn't have a drop that would fall in exactly that place in exactly that way, or it's extremely unlikely. But the other thing about this so-called mixture, mostly Nicole Brown Simpson and less of Ronald Goldman on the RFLP probes, is Dr. Lee addressed this, if you recall, when he pointed out the bag in which the boots were taken. Do you remember that? This was the wet transfer of blood coming through the bag here. When these boots are taken off and it's dragged into an area where there's blood from both victims, and then the wet blood is put into the bag, any kind of typing that you're going to get, if there's a drop on that area from a mixture, the DNA test is suspect when you handle the evidence in this fashion in terms of getting a mixture. So that's a point for your consideration, I think. Now, what's left in this analysis is the Bronco, the Rockingham glove, some short final remarks, and you'll be hearing from Mr. Cochran. The first point I'd like to make when we talk about the bloodstain patterns in the Bronco has to do with something that Ms. Clark said, first of all, about the blood drops in the foyer in Mr. Simpson's Rockingham residence. If you recall, in her closing argument, she said, and I don't know how could she say this in terms of the record, that the blood drops that were found in the foyer, recall there were 3 that were recovered by LAPD, and then when Dr. Lee went back there, he found another 3 smaller cast-off type drops. And she said, well, those drops couldn't be made by a cut on the side of the finger, comparatively superficial cut on the side of the finger. Would have to be made with a major cut or that fish hook type cut, because that's their theory, right? That there's this fish hook type cut on the knuckle that nobody sees. Nobody sees. No one. On the way to Chicago. But Dr. Lee testified about this at page 43022 of the transcript. Question. And he's talking about the blood drop pattern in the foyer. And so if one had a superficial cut on the side of a finger and shook it in the fashion I'm doing, and then Mr. Scheck let the record reflect I'm shaking my hand down, does that create the cast-off pattern? Yes. And that would that be consistent with what you found here? Yes. And could the pattern that you found here be consistent with the superficial cut on the side of the finger? That's talking about all the drops. Answer was consistent with a small volume of blood. Is the pattern that you see here consistent with a major cut? No. So you have Ms. Clark's speculation, and then you have directly contradictory testimony by Dr. Lee, and there is no testimony in the record that supports her contention. It is mere speculation on her part. She is not a bloodstain expert, and I submit to you, you have to take the sworn uncontradicted testimony. Now, we know from what was said to Dr. Batten, that in the course of getting things together on leaving, Mr. Simpson sustained a cut going into the Bronco, retrieving materials on his way out packing, and that it's the position of the defense that the bloodstains that you see and, well, briefly, why don't we pick out that board, and I'll come back to it. This is the prosecution's bloodstain pattern in the Bronco board, if you recall it. Now, there are bloodstain patterns in the handle, instrument panel, console, of course, and then these are other items. That's the footprint area, and on top of the windowsill. Okay, and the windowsill is somewhere around here. That are consistent. Everybody agrees with a cut to the left hand. Somebody getting into the car, sitting down looking for something. Consistent with our theory. Consistent, arguably, with their theory. But then when you start looking at the rest of the bloodstain patterns, you have to start asking which interpretation is reasonable. Now, the first point that has to be made, take this down for a second, is that, of course, initial deposits would be made by Mr. Simpson that evening, and then somebody else was in that Bronco. Now, we know someone else was in that Bronco, and that's been, I submit to you, demonstrated by the evidence. Let's take a look at this picture. Mr. Cochran has already reviewed with you the testimony of Mark Furman at the preliminary hearing, and you heard it on videotape where he said he found blood in the Bronco, a bit of a Freudian slip. But I submit to you one of the most significant moments has to do with the testimony of Dennis Fung and the bloodstain patterns on the door sill of the Bronco. You recall that Detective Furman testified at the preliminary hearing at this trial that he observed 4 brush mark bloodstain patterns on the door sill of the Bronco that he could observe when the door was closed. When Mr. Fung came in, he circled these pictures. And if you recall his testimony, the bottom circle closest to the door, that's only one stain. He said that that stain could be observed when the door was closed, but the other 3 stains that are represented by those other 2 circles could only be seen when the door was open. Could only be seen when the door was open. From their own witnesses, evidence he was in the Bronco. And it only makes sense that he would go in that Bronco. And how much credibility do you really put in that man's testimony? But here's evidence that he was in there. You know what other evidence there is? There's one of the most interesting facts, and it's hard scientific evidence that supports our position with respect to the bloodstain pattern in the Bronco, the steering wheel. You recall that the typing on the steering wheel was 1.1, 1.2, a genotype consistent with OJ Simpson, and 4. Who is the contributor of the 4 allele? That was an issue, and much was made of it in the case, was it not? Lots of cross-examination, lots of highlighting of that 4 allele in the steering wheel. And the prosecution well knew that it was the contention of the defense that Mr. Furman and or other officers had been in the Bronco. Doesn't take much to get a blood sample, or you just take a swab, and the testimony is you run it through somebody's mouth. You can do a quick DQ alpha test. What is Mark Furman's genotype? We know that Andrea Mazzola and Dennis Fung, just like you do eliminations, their genotypes were taken, so we would know what they were. They are not consistent with the 4. None of them has the 4. They're eliminated. Why wasn't Mark Furman eliminated? Why didn't they take exemplars from the police on this? Why? But I think that a fair inference consistent with innocence, which you are under oath obliged to take, you must consider that Mr. Furman was in the Bronco. And the evidence is that a picture, around 4:30 in the evening, he is pointing at that glove at Bundy, walking through a pool of blood. Now, comes in to that Bronco, the vicinity of that Bronco, the area of 5 in the morning, right, initially, then goes out and does his circuitous little trip where he finds the glove and is alone for 15 minutes around 5:30. Now, there's very interesting testimony from Dennis Fung at page 21438 of the transcript about the ground. And he's talking here about Furman, and he's talking about Van Adder. He's talking about arriving initially at the Rockingham location. And he talks about how he was shown a red stain on the driver's door of the vehicle and a blood trail. And his question, okay, did you notice anything about the temperature at that time or the weather? Answer, it was fairly cool. What about the lawns? Did you notice anything that looked like it could have been dew on the lawns? Answer, I did notice there was some that the grass was wet. Question, all right. So Fung tells us that the grass is wet, but we know that there's no dew. We introduced into evidence under 1280 the weather, and when it was introduced, and you can take this back into the jury room, you can examine the areas that are highlighted in purple. The only thing it doesn't really make much of a difference to be tricky about is Professor McDonald explained all of this, that when you look at the time listing over here, it's standard time, so anytime you see a time, you have to add an hour. But when you look at the temperature and the dew point, you're going to see that the temperature was always many degrees above the dew point. So in other words, when you look through this, you'll see there's no dew. But the grass was wet, and you were at that location, and you noticed the sprinkler heads in the sprinkler system, and right in that area, that grass area where the Bronco was parked, there are 6 sprinkler heads. The grass, a fair inference, was watered regularly at that location. The grass was wet. That's the fact. Now, if you have, as Agent Bodziak indicated, blood that is caked on the inside of your shoe, even if loafers like Mr. Furman in the inside heel area, in your shoe, and then you walk through a wet area and then you step onto the carpet, you're going to get the same kind of pattern that was testified to for the prosecution side in terms of the fibers going into the shoes and getting out blood that would be consistent with the genotype of Nicole Brown Simpson that is found on the carpet of the Bronco. Then we have the issue of the blood stain pattern on the console. Now, let me be precise, because when Mr. Cochran was showing you about the 7/10 of a drop of blood, I just want to make sure that I saw even the prosecutors with a quizzical look. But that happened, I think you recall, at the very end of the trial. And that was a testimony of Gary Sims. You recall that he came back, he was testifying about the RFLP tests and the combining of all the stains. And I asked him a series of questions about combining all the stains. That is, the collection on June 14th from the console of 30 and 31, then the August 26 samples, 303, 304, 305. And we talked about the amount of DNA that you would get. With 1 drop containing 1,000 nanograms of high molecular weight DNA. And then when he looked at the amount of DNA, when you combined all the samples, he said that it wasn't over 100. And question, so that is 1/10 of 1 drop of blood. That's what it is. 100 nanograms, 1/10 of 1 drop of blood. And he said, qualified it. He said, answer, well, you have to remember with a drop of blood, for example, if you were testing liquid blood, that is not the same as extracting DNA out of the stains worth of 1 drop of blood. So you're not quite talking apples. You are somewhat talking apples and oranges there, but in terms of the ballpark you're talking about, maybe getting 3/4 of that DNA out, so you can figure it from that. So then I asked him a question to try to make it English. All right, So what you're basically saying to us is that maybe if you're just dealing with a pristine drop of blood, you wouldn't get 1,000 nanograms, you get 750. Answer something like that. Is that what you just said in English? Answer yes, that's what I said. Okay, so if we were to summarize, and I mean no disrespect, so if we got about 100 nanograms of DNA and there's 750 nanograms in a drop of blood, can you give me that fraction quickly? That would be about a seventh. Answer something like that. Okay, so in other words, make it very, very simple. Hard science. When you combine the amount of DNA and you give them all favorable inferences, Gary Sims, their own witness, says, when you look at the smears of blood on the console, it's 7/10 of a drop. And now, how could that be, you're saying? Let's say it's a drop or two. How could that be? Well, that's because, as Dr. Lee explained, that when you have a blood drop and you smear it over a non-absorbent surface, it smears. So it looks, small amount of blood can make a big smear. And of course, Mr. Goldman's contribution to that 7/10 of a drop of blood is at the most 30–40%. That's very, very, very little. And so then you have to ask yourself, does this make any sense? How could so little, even if we assume, how could so little be there? How could so little be there? Ms. Clark was trying to say, well, this is how the blood got there. We know the Rockingham glove had a lot of blood, mostly from Mr. Goldman, some from Nicole Brown Simpson, and that was somehow placed on the side of the console. So that's why we get the little amount of Goldman's DNA that's on the console. That's their theory. Well, that's consistent with Mr. Furman placing the glove in there. It's consistent with even Mr. Furman having handled the glove and getting blood on his sleeve and just searching around the area, or one of the other police officers, and just getting a small smear of it with his sleeve on the console. That's consistent with this evidence. And you know what isn't consistent with this evidence? Think about it. What are they really saying? If Mr. Simpson had committed these murders and he grabbed the glove, as they're saying, with his open left hand, all right, and placed it on the side, well, then in getting into the car, why aren't there mixtures on the window, right? On the window, on all those other drops, everything else, all those other blood stains, there's no trace of blood from either of the victims. There's no mixtures. Wouldn't there be other blood on the hands? And of course, their theory before you, this is extraordinary, is that he's wearing these clothes that we've just been through the evidence of struggle. If there's blood on pants, it's going to be on the seat. If there's blood from the struggle with Goldman, it should be there. We know there's no hair, there's no trace, there's no fibers from clothing, there's no berries. There's nothing in that Bronco that would be consistent with somebody that had committed a violent double homicide, that had been in a life and death struggle with Mr. Goldman. It doesn't make one bit of sense. If you look at the bloodstain pattern in the Bronco, you have to have a reasonable doubt about that. And haven't we shown you by credible, fair, and reasonable evidence that this Detective Furman would have gone in that car and by his own testimony and exposed lies from the prosecution's own witnesses, there's evidence he was there. Those stains on the door sill give up the lie, don't they? He was in that car, and probably more than one of them was in that car. Now, with respect to the credibility of the evidence, very briefly, and I know you followed this, we have to make a distinction. In her opening statement, Ms. Clark actually said to you that all she was going to talk about in her opening statement with respect to the Bronco were the stains that were collected on June 14th. She didn't even indicate they were going to offer you anything from after August 26th, because they know how terribly this was handled, and that no jury could really accept the integrity of the evidence after this car was abandoned. But could we bring up the board, please, on the 13, I think it's 1351. The DNA board with the very briefly, you recall this, and we made a distinction here. We have to look at the samples that were collected on June 14th, and the samples that are collected on August 26th, as Dr. Gertie suggested to you, if you look at the June 14th DNA evidence, okay, with samples 30 and 31, nothing in 30, 31, they're calling this faint 1.3 allele, where the 1.3 is showing up in the controls. And you remember the whole business about development length and the notion of controls failing. This is it. From June 14th, this is it with respect to DNA from Mr. Goldman and the Bronco. That's it. And as Dr. Gertie's indicated to you, that is not credible scientific evidence. Of course, they're offering you evidence that was collected on August 26th, after this vehicle was literally abandoned, after the no special care hold had been taken off it, after there was a theft. Now, Mr. Mraz, he wasn't the world's most credible witness on the issue of the theft, but I really think that's besides the point. Number one, he's stealing, he's inside that car. What's going on? He didn't see blood, but you don't have to accept Mraz. What about Detective Moldorfer, who's investigating this? She doesn't see blood. And then there's Mr. Blazzini. He doesn't see blood on the console. And we know that there's all kinds of people allowed into this vehicle, and probably more disturbing than anything else, as Detective Moldorfer indicated, the rules are violated, and there is no record kept of any authorized police personnel, of any police personnel going in and out of there. They could just go in and out and no records were kept and nobody would know, period. And all of a sudden, what we have on August 26th, when the car is finally brought in, and Ms. Clark said it was she must have misspoke when she tried to imply that the inspection of the Bronco was at the request of the defense. Those are not the facts. The facts are that they brought it in, they allowed the two defense people to observe, and then Michelle Kessler looks in the vehicle, and there's a photographer that was brought down from Life magazine at the behest of the police commissioner to witness this grand examination of the Bronco, and lo and behold, they find as much blood on the console on August 26th as there was on June 14th. And then when they do the DNA testing patterns, they find not only traces of Mr. Goldman's blood, but Nicole Brown Simpson's blood in those same areas. That is awfully odd. So the integrity of the evidence, again, is in question here in terms of what you can accept beyond a reasonable doubt. But even if you're willing to look aside from that, and I don't really think that one can, in fairness, I think that the defense version of how the blood got there and the bloodstain pattern in the Bronco is far more plausible than the prosecution's version. It just doesn't fit. There would be mixtures on all those stains according to their own theory. There should be more blood in the Bronco, given what occurred in this case. The bloodstain patterns don't make sense, do they? They really don't. And nor does the hair and fiber in that Bronco. Now, let's talk about the glove. The first point to be made about the glove is an integrity issue. And that is that you recall that when Mr. Yamauchi opened up the reference tube in the morning and spilled out the blood, the first thing he did after that was this examination of the Rockingham glove. And as you recall, he was putting his initials in, he was doing all these phenotesting, these manipulations, all in the wrist area of the glove and manipulating it. There is so little DNA in these few areas here from the D1S80 tested, minuscule nanogram amounts, very, very small, consistent with a small sample handling transfer from Mr. Yamauchi. And that alone, I think, can explain the small amount of DNA on the glove. But of course, under the other scenarios, the competing scenarios of the defense and the prosecution, if the Rockingham glove was up against the side of the console, that certainly would, of course, explain a small transfer of Mr. Simpson's blood into the heel area of the glove. But you know what doesn't make sense? What doesn't make sense is their theory. First of all, the tight glove is thrown off from the left hand in the course of the struggle. But they're saying that with a cut, a bleeding cut, the fish hook on the knuckle, which nobody sees on the way to Chicago, and blood on this hand, the gloves are taken off. Can they really suggest to you that gloves are taken off at the wrist? I'm from back East Brooklyn, I wear a lot of gloves. You may not have as much experience. But think about it. You don't take gloves off like this, you take them off like that. And you know what? That's exactly what the criminalists were thinking. That's what Gary Sims was thinking. Even Mr. Yamauchi was thinking that. Because most of the initial DNA testing all was done looking for blood on the fingers, top fingers of the glove. Because that's all that makes sense. And there was nothing there. And that's got to give you, I would submit, a reasonable doubt. So what I've tried to do in my remarks is review with you essential pieces, circumstantial evidence of the prosecution's case. And we don't have to do that. We don't have the burden of proof in this case. And each essential piece, I think it's fair to say there's a reasonable doubt. And some of these are so profoundly disturbing in terms of the manufacturing of evidence in this case that I'm sure you really can't abide it. Not in this country, not in this democracy, can we allow dishonest, manufactured evidence to lie at the heart of a case like this. It cannot be. You cannot trust. I mean, you cannot go back and say, well, maybe they planted evidence on the glove, maybe on the back gate. No, there's blood missing. Big deal. How can that be a big deal? There's many, many reasonable doubts embedded in all of that. But there's a fourth C. Contaminated, compromised, and corrupted. But there's a fourth C that goes along with how these things happen that relates to this forensic testimony. And the fourth C has to do with cover-up. And I'm not even talking about the statements of the police officers and the cover-up of Mr. Furman that Mr. Cochran has discussed with you so eloquently in the last 2 days. Let's just talk a little bit about the criminalists and what you can view in terms of that evidence and how that affects on their credibility, because if you lie in small things, and some of these are not so small things, you lie in big things. And if you're trying to turn the other way and cover up real problems, serious problems, you can't abide it. Now, one I alluded to early, and I just think it goes to the heart of the hair and fiber evidence in so much in this case. And your common sense tells you. They moved Mr. Goldman's body. They were traipsing around that crime scene. And we know the envelope was moved, and we know the glove was moved, and somebody put it back. And remember, Mr. Fung, they actually have a form. If the scene was altered, describe how. And Mr. Fung says, it's not my job. We don't ask. Detective Lang, do you know? I don't know. Did anybody ask Jacobo or Ratcliffe, the coroners? Did anybody come in and do an investigation? Isn't it important to know who's moving around this evidence, that they're going to come in and make a big deal about hair and fiber and other things? Don't we have to know that? Isn't that just fair dealing with you? And they're covering this up. They're covering up how miserably this was handled and how the integrity of the evidence was compromised. It's as plain as day. It's an insult to your intelligence to say otherwise. Why? They have a responsibility to come in here and do that. And we looked at videos where I submit to you there's a glove on the blanket that somebody put back. And then there was the testimony, Detective Lang said, and if this isn't covering, I don't know what is. Well, why did you move the bodies? Why did you wait so long to bring the criminalists in? Why did you move the bodies before you collected the evidence? Because that's lunacy. And the answer was, this is what you call a closed-in crime scene. And in a closed-in crime scene where the evidence is close to the bodies, the first thing you do is move the bodies? That was a makeup. It was nonsense. As all the other criminals who came in here and testified, even Mr. Fung couldn't abide that, because it's covering for mistakes. Now, another one is just the whole way it went. Mr. Fung, when he testified in the grand jury and initially at the preliminary hearing, he forgot Andrea Mazzola was there with him because she was a trainee and she played a big role in this case in handling the evidence, and they wanted to forget it ever happened. And, you know, that's the way it was. And, when I asked him, well, was there any concern in the lab about this before you went to testify in the grand jury of the preliminary hearing? No. It's just this habit I have of saying I when I mean we. It's a habit of testifying. But, when Ms. Kessler came here, she was actually asked by Mr. Neufeld, was there any discussion before Mr. Fung testified in the grand jury about what went on in this case? And they said, well, there was some concern that Ms. Mazzola was listed on the forms as the officer in charge. And I think that tells you all you need to know. Of course they were concerned about that because they realized that the whole scene had been miserably botched. And there were serious problems here with the integrity of this evidence. Then, of course, there was the handoff of the envelope. And just as a quality of testimony. I mean, Mr. Fung said, oh, I wouldn't take that envelope, pick up that envelope with my bare hands. And then we showed it to him on videotape where he's picking up the envelope with his bare hands. And then he goes, well, that couldn't have happened because the coroner, Mr. Jacobo, wasn't there, so I have the timing right. And then we showed him the videotape of Mr. Jacobo walking by that he was still there. Well, there's something wrong with the quality of testimony like that. There's something wrong when Ms. Mazzola conveniently begins to close her eyes because problems arise on how the trash bag is carrying this blood vial out sitting on the couch. There's problems with the whole trash bag story. There's problems, there's an extraordinary problem with Ms. Mazzola suddenly forgetting that her initials are on the bindles. And the only credible testimony is that they were there and something's wrong. So when something's wrong, people's memories get selective and testimony comes in funny ways. Dr. Goldman, the coroner, never showed up. Mr. Martz destroyed his underlying digital data and didn't save much of the data. Mr. Martz stopped looking in terms of testing. Mr. Rubin stopped looking pretty early. We have an EAP exclusion on the fingernails that they're desperately trying to change. And then, of course, there's Ms. Kessler can't even remember the substance of the meetings that were had early in the case about security of the samples. And then that was remarkable. Remember when Ms. Kessler, when we were talking about looking for blood on the sock, and it said blood search not obvious? And then remember that testimony which said, well, that wasn't a blood search. Well, it says blood search right here. Well, that wasn't a blood search. I mean, some of it was remarkable. And then, of course, there's the Thano-Paratus tape and the missing blood. There's a lot of it. I'm sure you remember more than I've just listed. Ladies and gentlemen of the jury, I thank you very much for your patience. I've tried to reason through this evidence, drawing the fair inferences as best we could, looking at the integrity of the evidence, and I just think there's very little question here, is there? So much of the essential facts in this case are just shot through with reasonable doubt. There is something wrong. There's something terribly wrong about this evidence. Somebody manufactured evidence in this case. There's missing blood. There's EDTA. There's questions, serious, deeply troubling questions. You must distrust it. You have to distrust it. You cannot render a verdict in this case of beyond a reasonable doubt on this kind of evidence. Because if you do, no one's safe. No one. The Constitution means nothing. This cannot, will not, shall not happen in this country with you good people. It just won't. Thank you very much.
Thank you, Mr. Scheck. You want to take a change over here?
Just 3 minutes or so.
All right, ladies and gentlemen, let me ask you just step back into the jury room. It'll probably be about 5 minutes. Reflect that we've now been rejoined by all our jury members, and Mr. Cochran, you may make your concluding remarks.
Thank you, Your Honor. Judge Ito. Again, to my colleagues. Good afternoon again, ladies and gentlemen. Seems like we did this yesterday, but I won't be nearly as long this time. I'm back, as I promised you I'd come back, to try and wrap up the defense discussion of the evidence with you. You just heard what I believe was a remarkable discussion by Mr. Barishek, an excellent lawyer. He may be from Brooklyn, but he's become a Californian as far as we're concerned. He is a very valued member of our team of defense lawyers for Mr. OJ Simpson. And you see why. This is indeed a talented lawyer. And so he shared with you a number of things which I will not be redundant about and go over. You have them clear in mind. And if I were not to say anything else, there are many reasonable doubts in this case, and OJ Simpson is entitled to an acquittal based on what we have told you. This is my last chance, of course, to speak to you, and I want to take this time to tell you again that the prosecution, because they bear the burden of proving this case beyond a reasonable doubt, will have the opportunity to speak to you last. We may not be here too late tonight because I'm not going to be much longer, and I think that more than likely, I think we can probably guarantee this case is going to get to you sometime tomorrow afternoon, so you can kind of sit back and relax. It's been a long, long, long road to get to this point. It's been kind of like a relay race, hasn't it been, in many respects, in this journey toward justice? The prosecution was first running with it. We then took the baton and we started running with it. We've run almost up to the jury box. And soon, we're going to pass the baton to you. This is how our system works. This is what makes it so great. We pass the baton to you, and we'll be glad we can then sit back and watch you at work. You watched us for a year, 2 or 3 days. Now we get to watch you. It'll be symbolically watching you because we won't see you back in that room, but you know we're going to be counting on you, giving both sides the benefit of your individual opinion. Now it's your time to perform. You know how you could think about us in those days when you wanted to criticize us? We're not going to criticize you, though. We're going to just watch you work. And watching you work is what makes this country so great. Because it's 12 citizens, good and true, coming together from this community from disparate backgrounds. Experience not required. Citizenship, the only requirement. To do justice, to do right, to right some wrongs, to straighten this out. That's what we're asking you to do. To follow the law, determine the facts, and come to a well-reasoned decision. That's what's going to happen tomorrow afternoon for you. Now, it may take 1 day or 100 days, but you've been committed. I know that you'll stay the course, keep your eye on the prize, and do the right thing. Now, when I sit down this time, I won't get another chance to argue to you or discuss the inferences because it has to stop sometime. But Ms. Clark gets to talk to you later tonight or tomorrow. And I want you again to use your common sense. And remember, if she raises some point, I may not be able to get up and respond, Mr. Sheck or I. If it's something that's not purely rebuttal, you may see more objections this time because we got to keep it in line. But if it's a point that we can't respond to, you substitute your wisdom and common sense as to any point. I think you know by this time we can answer anything that they would say. So I'm sure you'll give her the same attention you've given us today, and I wish them good luck. In fact, let me say this. In this case, we have been advocates. We have fought hard, I hope. But it's not personal. What is personal is this case. What is personal is our zeal and our desire that our client be acquitted. It's not personal against these prosecutors. In this part of our discussion, I want to share a couple of things with you and clear up a couple of things, if I might. Remember, I was examining Detective Lang, and it was interesting that we saw Detective Lang here today. That's interesting, isn't it? Detective Lang was here. He's the only one who can really come anymore. We discussed the roles of these people. It's the only one who's going to show his face here, could count on. But Lang says that early on that I asked him questions about traveling around the world to investigate this case, to get an idea of what resources were they putting on this case. You remember right at the very outset, the reason that robbery homicide was put on the case was because downtown they supposedly had better resources. There's some doubt about that, but they did that, and they put resources, including everybody in the LAPD. They had the DA's office and their investigators. They've had the FBI. They've been all over the world. You know, they've been everywhere looking for Bruno Magli's shoes. They've been to Italy. They've been to many of the states in the United States. And I asked them about those things to give you a scope of what they were trying to do. And, you know, it's awesome, the power of the state. And at one point, I worked the assistant district attorney, so I know about power of the state. There's no priority to being on this side. I used to be on this side. You can be on both sides. You perhaps gives you a little different, a balanced perspective. But they have a lot of power. They can do a lot of things. They have a lot of resources. And they've used them in this case. So don't feel sorry for them. They've used every resource they had. When they didn't call people, there was a reason for it. It wasn't they didn't have the resources. These are excellent lawyers. They know the facts. If they didn't disprove something, if they couldn't disprove Henry Lee, if they didn't call anybody for John Gerdes, it's because they couldn't find anybody. Earlier, I talked to you about Detective Furman on this particular point. I wanted to make sure so we could be as accurate as possible. This question was asked by Bailey. There is a problem that has been brought to your attention, isn't there, Detective Furman? Answer, no. Question, when discussing this event in the preliminary hearing and talking about the glove, your tongue slipped and you said them, didn't you? Answer, yes. In case there was any question about what we'd said earlier. Mr. Scheck has covered the brush marks on the door, but what I'd like for you to do is look back at your notes, because Furman said that regarding these brush marks, he said he saw these marks on that door while the door of the Bronco was closed, remember? And the reason why this has become so important was he was trying to say he hadn't gotten inside. Then we called Larry Regal, who said you couldn't see the ones at the top unless the door was open. And then Furman also had said that he told Fung about these brush marks. If you look at Fung's testimony, I think you'll find that Fung never says that he heard that from Furman. And so, you know, with regard to Furman, I could have gone on and on and on about lies, but that would be counterproductive after a while, because you know who he is now. There's one other point I wanted to share with you about Furman before we take our leave of him, is that there was some questions in counsel at 18906 about opportunity for Detective Furman. And here was a series of quick questions. When you arrived at the scene this night, were you wearing a coat, a jacket of some sort? When I first arrived at the scene, yes. Can you describe it? Answer, a blue blazer. All right. And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove. Yes, tan slacks. Okay, now, at some point, did you walk back to your vehicle and take off your blazer and hang it to lay in the vehicle somewhere? Yes, sir. Okay. can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10, that's a.m. It would be after I was relieved from the case. Now, he's relieved a short time after he gets there. He's relieved by 3 o'clock, isn't he? Before 3 o'clock. All right, that would be close to 3 o'clock? Yes, sir. Question, and that is when you walked back to the vehicle and left the jacket and stood waiting for your relief? Yes, sir. Now, I don't believe hardly anything he says, except that it is true that in this photograph taken at 4:30 or before sunrise, the one you saw where he's pointing at the glove, he doesn't have a jacket on. So he had a jacket, went to that car by himself. There's many things in that car. This man had ample opportunity to get up to that scene. You know, as I told you, it's so stretches the credulity to believe that so neatly placed were this knit hat and this glove. Were there two gloves at some point? When he says, I saw them, why would you say them? There weren't two gloves. And, you know, it's so unusual because everything else is spread all out. This was a vicious fight. There's a beeper over here and there's keys over there. But these items are right there, right where he could point at them. It's two packed. So you can ask yourself those questions when you go back into that jury room. Now, in this case, I discussed with you Miss Juanita Moore, a lady that I called to the stand, and I think I misspoke myself. I think I mentioned to you that, I think I may have said, she said that Mr. Simpson did not have dandruff, and if I did say that, I got that wrong. She said that Mr. Simpson would get dandruff, I think, in the off-season, in the spring and summer when he was here, as opposed to when he was in New York, and I wanted to make sure, in looking at the transcript over the lunch hour, I noted that. Ms. Clark seemed to be amazed when Mr. Scheck said that Kelly Moldorfer said that she didn't see blood in that Bronco, so to save her some time, I'm going to read you the transcript. Kelly Moldorfer at 38268, lines 26 through line 9, I think of 38269. Question, and when you looked at the console, do you remember seeing any blood there? Answer, no, I don't have any specific recollection. That's the lady, the investigator, who was looking at this. And so now we come to some jury instructions, which I think have some real relevance as we conclude this case, hopefully. We've already talked about a witness willfully false. We've talked an awful lot. You now know a lot about circumstantial evidence, and I dare say you know the difference between direct and circumstantial evidence. We won't talk further about that. And you know what happens where the proof circumstances are equally consistent, one of which points to innocence, the other which points to guilt, where they're both reasonable. You must adopt that which points to innocence. You understand that. You understand about circumstantial evidence, so enough about that. And we've displayed this, and we talked about how this works and how it inures to the benefit of the defendant because there's this burden of proof. But there's another instruction which I want to talk to you about now, and this is one that where the prosecutors keep wanting to change things around and ask what we proved and what we didn't do. This is what the law is. The prosecution has the burden of proving beyond a reasonable doubt each element of the crimes charged in the information, and that the defendant was a perpetrator of any such crimes. There's no doubt about that among any of us, is it? The defendant is not required to prove him or herself innocent or to prove that another person committed the crimes charged. So now, if that's what the law is and the judge gave you that, or Mr. Darden asked the question, who did this? Who committed this crime? Why would he ask that when the judge just said, the defendant doesn't have to show anything? And we know in this case, they rushed to judgment. They didn't look at anybody else. That's a question he should be asking these detectives, not us. We're the ones who had the preeminent experts who wanted to help out. They wouldn't accept them. Could he ask us that question? How could he ask us that question in good faith? So what the answer is, you go ask your detectives. That's the answer. Now, he asked another question. He said, well, where was OJ Simpson? And he says, well, you know, how does he account for his whereabouts after 10 o'clock? Well, let me just take a minute about this. He asked that question. So let me answer it for you and for him. Some of you in your former life probably lived alone. If you lived alone, if something happened between 10 o'clock and 6 o'clock in the morning, it's real difficult if you live alone to prove where you were if nobody lives there with you. Isn't that true? Is that common sense? Mr. Simpson lived alone. But we've done more than that. We can establish where he was. He was at home. That Bronco was outside. He was packing and getting ready and rushing around at the last minute and coming outside to that Bronco, getting his phone, getting the paraphernalia for that phone. That's what he was doing. He was packing. He was getting the golf balls, the golf bag out of his car that was seated out there. He was getting golf shoes and whatever goes with golf if you're a golfer. That's what he's doing. He's getting this little knapsack out that has golf balls in it. And he was bringing another bag down, all of which were ready when Park, Cato were out there. And he comes down with the other bag, carrying it. That's what he was doing, Mr. Darden. That's where he was. It's your speculation. He's on the side of his house running into an air conditioning. That didn't happen. That's unreasonable. Nobody here believes it. It's not going to help save their case. They're speculating again. Speculating. Cynically speculating. And it's not going to work. And so that brings me to this other instruction. It's called alibi. You remember during voir dire, I asked you about this. I said that you won't place a bad connotation on the term alibi. That's what the law calls it, alibi. And it says as follows, that evidence has been received for the purpose of showing that the defendant was not present at the time and place of the commission of the alleged crime for which he is here on trial. If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Can I repeat that last part for you? If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed. It doesn't say you might find him not guilty. You might think about it. It says you must find him not guilty. And so, you know, when you talk about this whole concept of reasonable doubt, and we'll talk a little more about that, it's how you feel inside about this evidence. It's how you feel inside about these messengers and their message. It's when you have that queasy feeling. You can't trust this evidence. Barry Scheck described it well as a cancer. He talked about one cockroach you don't need to see anymore, because you know if you see one, there's a lot of them around. All you need is one, and that's going to make you go the other way. In this case, you don't have to get past the socks. But then you get to the glove and the Bronco, and you get to all of it, none of which you can trust. And then how do you do it? Do you get back there and say, well, I don't trust him on this. I think I can trust him on that. When these essential link in the chain is broken, you got reasonable doubt. And so your job won't be quite as tough as you may have thought. Reasonable doubt? In this case, the prosecution has not offered one coherent theory to explain how these deaths occurred. I won't talk about Thanoparatus and the desperation that brought about, but let me talk to you about this whole concept of what took place in this case. One of the things that was intriguing to me, and I'm sure you've thought about it, and I know that your collective minds are far better than mine and Mr. Scheck's, but you know, we think about things that'll be helpful to you. You know, one of the things that's always troubled me about the prosecution's case is, you probably thought about this, Cato the dog was purchased by OJ Simpson after The other dog died. Remember, Arnell told you about how they had to bury the dog, and it was a real tough time for the kids and all. OJ had that dog, Cato, along with Chachi, the other dog, over at Rockingham. And he let his son have the dog because they named the dog after Cato, who is now living over with OJ Simpson. That dog knows OJ Simpson. It's his dog. He bought the dog. They didn't know this as they were speculating. It's his dog. If OJ Simpson had been the one there that night, that dog would have followed him out the back gate. He wouldn't be going out the front. Those paw prints wouldn't be going out that way and down the sidewalk soft. That's common sense. They said use your common sense. They make sense to you. The other thing is the one thing that you can count on in this case is these two people, even when they weren't getting along, loved their children. And their children loved them. Whether it was pediatric AIDS affairs, whether it was recitals, whether it was sunshine preschool affairs, just look at the month of May, the things that you heard that OJ Simpson went to. Always on the weekend because he was traveling. Wasn't no fuse, he was out of town working. He was the breadwinner. So whether it was the pediatric AIDS or something for his children's school at 400 people over at the Rockingham estate, he was always there for the kids. If it meant coming back from Chicago on Friday or from wherever he was in New York on Friday to go back to Chicago on Sunday to go back for an engagement, he came home. He came home because his little girl was having a concert. That's the kind of dad he is, and somebody has to stand up for him. People don't want you to stand up for him. People can't stand the truth, but they're going to hear truth in here. There's one place you can't take away somebody's voice, and that's in the courtroom. When you want to tell the truth. For 16 months, this man sat over here and heard people talk about him day in and day out, judged him and prejudged him against the American way. What right? How dare them do that? And he has 1 day or 2 days to have somebody stand up for him. And people are crying and moaning. It's outrageous in America. It's intolerable, if you will. And so this is a good and decent man. Loves his family, loves his kids. None of us are perfect. But he's a man who went a long, long way. Raised primarily by his mother, you know what he did with his life. He had a good life, a wonderful life. He's done well. He's not going to give all that up, try and kill somebody with a knife. He's not going to give that up. And you know what? As you think about this case, can you imagine that a man who loves his children so much is going to go over, kill his ex-wife, kill their mother, and leave her so that the children can come downstairs and find her? That defies credulity. None of you believe he would do that. It's contrary to everything that you can believe and that you've heard about this man and what he's done and what he's done with his life. So forgive me if I speak out for OJ Simpson. If I'm so presumptuous as to believe that the Constitution means that you're presumed to be innocent until you make the decision. Nobody outside here has a vote. You have that vote, thank heaven. These narrow-minded people, thank heaven they don't have a vote. You will have the final say. And so, this concept then of reasonable doubt. What then does it mean? We've heard about it. We've talked about it. We have a chart. I'm going to ask Mr. Douglas to put over there. Let's talk about this whole idea of burden of proof and reasonable doubt and what is reasonable doubt. You remember during voir dire, I talked to you about this concept of reasonable doubt. And before we go to that chart, I mean, it's that state of the case after the entire comparison and consideration of the evidence leaves the minds of the jury in that condition where they cannot say they feel an abiding conviction of the truth of the charge. That's what reasonable doubt is, and let's go over it one more time because this is the cornerstone of every criminal case. What it really is a doubt based upon a reason. In this case, we have given you myriad reasons. There are many, 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 many reasonable doubts. It's not just one, all of which lead you to one verdict in this case, and one verdict only of not guilty, but let's go over it one last time together. A defendant in a criminal case is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving him guilty beyond a reasonable doubt. You've heard a lot about that. That's what people need to learn and be reminded of in this country. Reasonable doubt is defined as follows. It is not a mere possible doubt, and we know that, because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case where, after the entire comparison and consideration of all the evidence leaves the minds of the jurors in that conviction, that they cannot say they feel an abiding conviction of the truth of the charge. That's reasonable doubt. It's not written just for OJ Simpson. It's for you. It's for you. It's for you. It's for all of us who are citizens. It's given in every criminal case. You have to give it. That's the burden. You don't change it once the trial starts. That's the burden. Let's see how it works. In this whole idea of a burden of proof, let's start down at the bottom and look at the burden that's placed upon the state. And they should have a burden like this. You're talking about taking somebody's freedom for the rest of their life or whatever. There are a number of things that you might want to think, but in a case, sometimes in cases, we actually can prove the person charged not guilty. And in this case, in my 32 and a half years, this may be as close as any case where somebody's been proven not guilty, because if you look at these facts, you look at what we've shared with you over the course of the last 2 days, this man has been proven not guilty. But that's at the very bottom of the rung. You may say, somebody among you may say, well, you know, I have some suspicions. I think it's highly unlikely, but I have some suspicions. Somebody else may say, well, it's less than likely, but, you know, I don't know. I mean, they didn't convince me beyond a reasonable doubt. And somebody else might say, well, you know, he's probably not guilty based upon this evidence. Somebody else will say, it's unlikely he's guilty. No way in the world is he ever going to go over and kill the mother of his children under these circumstances. That the timeline shatters their case. Somebody says, I don't trust the police. Furman was central. I don't trust Van Adder. It's the messengers and their message. It just doesn't fit. Something's wrong. There's a cancer here. Possibly not. Guilty? Maybe not. As Mr. Sheck said to you, you know, maybe not's not good enough when you're talking about somebody's freedom for the rest of their lives. Well, then somebody else may say, well, perhaps, gee, I don't know. I suspect that he might be. Maybe he's possibly guilty of something. Maybe he's probably guilty. Maybe guilt is likely. Maybe guilt may be highly likely. I don't think any of you are going to find this case, because I think we've shown that we've proven he's not guilty. But all of those levels, from proven not guilty to the guilt highly likely, is our interpretation of what you have to do before you get all the way up to guilt beyond a reasonable doubt, so that you won't have that queasy feeling about this case, where you can believe to an abiding conviction of the truth of these charges. Can you have that? I think not on this evidence. Not on this evidence. Not on this case. They have failed. You know, we ask you a question. Did you have the courage? Did you have the intestinal fortitude to walk back into this courtroom? If they failed to prove Mr. Simpson guilty, did you have the courage to walk back in and say, we find him not guilty? And you said you could do that. That was part of your job. You said you could do that. I'm going to hold you to that, because that's what makes the system great. Your courage, your willingness to stand up for what is right. And so, in this scenario, now thinking about reasonable doubt even more, the prosecution had a puzzle. And it was interesting how they did this puzzle. Technology is wonderful. And you saw they kept, under this puzzle, putting on pieces and that sort of thing. And so we thought about that. I thought about this puzzle. Thought about what it meant in this particular case. I got a call from a very, very wise lady who reminded me that if you've ever gone to the store and bought a puzzle, when you buy a puzzle, on the outside of the box of the puzzle, there's a picture. So you know what the puzzle looks like when it's finished. Well, in this case, the prosecution took a photograph or picture of OJ Simpson first. Then they took the pieces apart. If they really wanted to talk about reasonable doubt, you don't jump to conclusions at the beginning. You don't rush to judgment and then be concerned about an obsession to win. What you do is you take the pieces and put them together, and then you come to the conclusion. They got it all backwards. It's like what they did with the Fourth Amendment. It's like asking us, where is this witness? What did you prove? Solve this crime for us. They got it all backwards. Don't you see? And so that little example, a jigsaw puzzle, was clever, but really it trivializes a man's fight for his freedom, who's always said that he was innocent from day one. So I wanted to just summarize our sense with a graphic, thanks to Mr. Bob Blazer, of this evidence and why there's reasonable doubt as to each of these items. Please note the monitor. All right, let's look at first. We know in the upper left-hand corner, there's missing blood. They can't explain it, and they went down in flames, going out with a home video where it was actually embarrassing this morning. You want a little levity during the tough times in your deliberations? Play the Thanoparatus video. In fact, it's so bizarre that if you listen to it again, you'll hear Hank Goldberg is laughing himself. He starts laughing when, if you look, the words are mouthed by Paratus. He goes like that, and Goldberg starts laughing at his next question. How embarrassing this is, but this blood is still missing. You'll have that syringe there. So, Mr. Blazer and Mr. Harris, what does that mean, that missing blood? It means reasonable doubt. Then we have the socks, my personal favorites. And when I talked to you about the socks yesterday, I may not have told you that in addition to the socks not being in the video at 4:13 on June 13th, and how they placed them there later, and how they were collected at 4:35 or between 4:30 and 4:40, Willie Ford came in here and testified to you he didn't see the socks. Forgot to tell you that yesterday. He testified they weren't there either. So thank heaven there's one person who wasn't part of that cover-up, although they got to him and he was saying things, oh, well, the socks may have been covered. But he still works over there. So we'll forgive him for that, but he didn't know what we knew about Lang and Mazzola and the time they were collected in their log. Plus the timing on the whole thing got them. And those straps on the bed further. So what have we shown you about the socks? Reasonable doubt. That moves to the back gate. What about that back gate with the EDTA and more DNA than you could ever imagine, and it's picked up and collected 3 weeks afterwards when people have been all over the place, and you saw the photograph? Look at that photograph. That photograph doesn't show any blood. It shows some little tiny spot. It was totally inconsistent. They're trapped again by the video. This case will go down as the video case because we have shown you for your own eyes why they lose this case, why there is reasonable doubt. So the back gate, reasonable doubt. And then we started out with the timeline because we knew at the outset the timeline with the witnesses that they failed and refused to call established a reasonable doubt. It shatters the prosecution case. If you start there, you'll find these witnesses credible. OJ Simpson couldn't have committed these crimes. There's reasonable doubt. He's not guilty. The timeline. We went from there to the EAPB, and you'll remember that, and Mr. Sheck has talked about it. I won't be redundant. The double-banded B, that's somebody else. They can't explain it. They never tried to explain it, except to talk to you about something that's not in the literature. It didn't work. There's reasonable doubt about who that person was. And so with regard to, and I see I've lost track of my chart there, demeanor, before we get to EPB, under demeanor, O.J. Simpson's demeanor, all those witnesses who didn't know each other, who you heard, who they talked to, you saw them all. You think that he was acting for those people? Do you remember that one of the most interesting things was Mr. Darden said that when the Scott Kennedy video at the June 12th recital, where a man just happens to stop by and takes a video, Simpson doesn't even know he's being videoed. This guy doesn't know Simpson. He's taking a video. Just came to us out of the blue. They had the audacity to tell you he was on camera. You didn't know anything about being on camera. Somebody's taking a video of you. How do you know that? But we had that video, and they have nothing else to say. You ever notice when they have nothing else to say, how they just say anything? That's an example of that. That's an example of O.J. Simpson's demeanor, and that was our answer to this so-called fuse. We had proof for you. You saw him on that date, and we took you through step by step through that date. We've already covered the EAPB, the Bundy blood drops that Mr. Scheck did such a great job on, and you know about those drops. You know the numbers as well as we do, and I won't go over those anymore. I think there's reasonable doubt based upon those, and of course you know the Bronco. How can you trust the Bronco? Chain of custody, how can you trust it? There's nothing you can trust about that Bronco and how they handle it. And then the gloves. The gloves didn't fit. The gloves didn't fit. The gloves didn't fit. Reasonable doubt. And then the why. Now, motive is not an element. The crime of murder, but absence of motive will tend to establish innocence. That's why Mr. Darden went to such a long and exhaustive study. And I've shared with you the fact that there is no motive in this case. But I just want to briefly tell you this about their theory at the end. If you believe what the prosecutors want you to believe, you have to believe that O.J. Simpson, who has a limo driver coming, I guess around 10:30, 10:40, after he goes and gets a hamburger at McDonald's, after having been worried about change because he had $100 bills, that he's already been packing because clothes are being brought down. He's taking his golf clubs because he is going to play golf, and that makes sense as a pre-planned trip. He's just off the road and going back on the road. That he is perhaps the most recognizable person in Brentwood in that area where he's lived, we know, for 17 years. That he drives a white Bronco. That he decides to put on a knit cap, and you saw that exhibition yesterday of him or you or I in a knit cap. He decides he'll put that on. He changes out of his tennis shoes, his Reebok tennis shoes, and his sweat socks, and puts on some dress socks, and puts on some Bruno Magli shoes. And let me just stop right there for a minute, put a pin in that. The Bruno Magli shoes, you heard all about Bruno Magli shoes and Bruno Magli shoes, and we searched all around the world, and we went to Bloomingdale's, and what did we find? There is nobody who ever sold O.J. Simpson any Bruno Magli shoes. They searched, they tried, they never sold him any shoes. So they just been talking about Bruno Magli shoes. I mean, there must be every other house in Brentwood. If somebody wanted to afford some Bruno Magli shoes, I guess they could. Now that's their case. There is no evidence that O.J. Simpson had any Bruno Magli shoes ever. In fact, when Lang is looking for the clothes and O.J. Simpson says, this is what I wore, here are the tennis shoes, he took only tennis shoes that night. There is no evidence that O.J. Simpson ever owned any Bruno Magli shoes, and please remember that. So he puts these Bruno Magli shoes on, and he's trying to disguise himself, of course. He puts on a pair of gloves that don't fit, and he gets in his car, and he decides that what he'll do is he'll drive over to the alleyway behind Bundy where his wife lives, in this big Bronco. Now, while he's going to do that, He's been over there a number of times, and you know they've already told you about Pablo Fenves and these people who live back there. You remember when you went on that jury view? There are homes and windows and things that face down on that alley, on both sides. From, I guess, Gretna Green side and from the Bundy side. People are looking down in that alley. It's well lit. You saw the photograph yesterday of what Mark Storfer would have seen. He pulls into this alleyway in this Bronco, in this disguise, dressed the way they want to have him dressed. So he's come and kill his wife. Now, somehow, they're trying to kill his wife or whatever. Doesn't kill her in the back there where the car is. He goes and lures her to the front gate. Doesn't make any sense, does it? He goes to the front gate to lure her to that front gate. And then he gets into a fight, somebody he doesn't even know. This fight goes on for 5 to 15 minutes. The fight is so fierce that a hat and a glove are torn off. That's how fierce this fight had to be. The keys, the beeper. You saw how tough it is for any kind of an altercation. For gloves to come off, for a hat to come off, there's kicking, there's all kind of fighting in this small area. But that's what they want you to believe. And so we find the keys and the beeper and the gloves, of course, we find specifically the cap and the gloves neatly packaged under the item there. And then he leaves this one glove behind and then just walks slowly out to the alleyway. Now, the dog that we heard so much about, who he bought, who was his dog, doesn't go with him. He goes the other way, out the front to go down the other way. Cato, the dog, under what they would have you believe. And he's got these bloody clothes on and everything. Now he goes back out there where his car has been sitting 10, 15, 20 minutes, right out there in the alleyway. Anybody could look, anybody coming home, people are driving up and down the street. Gets back in his car, then presumably he races back home where the limousine driver who's there doesn't hear him come up, doesn't see him, doesn't do any of those things. And we know from the time they see OJ Simpson, within 5 minutes, he's coming downstairs, packed, luggage is already down there, looking neat as a pin, heading for the airport. Now, he was expecting this man after he came back from the hamburger. This is what their case is. This is what they want you to believe. And just for good measure, that's not enough. That's not enough. Under their scenario, once he gets home, after he's rushing, he's got enough time, he's got all these bloody clothes on, he runs down the side of his house, where he's lived for 17 years, and runs into the air conditioning. It says, oops, no marks, of course, on his body, but while he's back there, he drops a bloody glove to match the other glove found over at Bundy. And just for good measure, so they'll be sure and find it, he knocks on the wall. He doesn't run into the wall, he knocks on the wall. He says, he gives a signal. Then he decides he comes in the house, but nobody sees him do any of that. That's what they have you believe. That is the prosecution's case. We have been here 1 year, ladies and gentlemen, and 2 days to hear this is what they have told you. It just doesn't fit. It doesn't fit, you must acquit. Something is wrong with the prosecution's case, and your common sense is never going to let you fall for it. So the other side, of course, we submitted in answering the questions that OJ Simpson was at home getting ready for his trip. He had no problem with his ex-wife. He had gone to this concert. She had gotten the tickets for him. There's no argument. Nobody's come in here, said they had any argument that day. There's no fight. They talked earlier, made arrangements for the tickets. He went to the concert. You saw him at the concert. You traced his steps that day and what he did. And then he went on to Chicago and came back immediately. And everything he did was consistent with innocence. This case is a tragedy for everybody. For certainly the victims and their families, for the Simpsons family, they're victims too because they lost the ex-daughter-in-law. For the defendant, he's been in custody since June of 1994 for a crime that he didn't commit. Someone has taken these children's mother. I certainly hope that your decision doesn't take their father and that justice is finally achieved in this case. One final word about Alan Park. We talked a lot about Alan Park. He's somebody that Ms. Clark, of course, found credible. But even credible people don't get everything right. Remember the golf bag? He thought it was a blue golf bag, and we know it's black with the insignia on it. We know that there was a lot of questions asked about whether you saw a car parked at the curb, and I read you the portion that when I questioned him where he said he hadn't really been looking. He was not very clear with regard to that. But like all witnesses, you hold them up to the same standard and look at them. And so now, I promise you we're going to coming to the end. If after hearing all of this evidence, you have a reasonable doubt, it is clear that OJ Simpson is entitled to an acquittal. And whether it is OJ or no J, the result would have to be the same. His status doesn't count. It's the evidence that counts and what's been proven to you under these circumstances. But he is a good and decent man who you have seen and observed every day we're in session since September 26, 1994. Now, as it comes time for me to conclude my remarks, I may never have an opportunity again to speak to you, certainly not in this setting, maybe when the case is over. As you've been told many, many times, there is a very heavy burden placed upon the people, and for good reason. Prove this case beyond a reasonable doubt. As such, it is Ms. Clark's duty to answer for you, as best she can, any legitimate questions arising from the evidence, which we believe casts doubt upon Mr. Simpson's guilt. There may be 1,000 such questions in a case like this, which can be put to her, but we intend no such exercise. I do think, after careful deliberation, that it might be fair to suggest 15 questions, just 15 questions, which literally hang in the air in this courtroom at this moment. And as the time approaches for you to decide this case, for us to hand the baton to you, I offer these questions now as a most important challenge to the prosecution. The prosecution which claims that it's met its burden in this case. If that burden has in fact been met, you will be given logical, sensible, credible, satisfying answers to each of these 15 questions. If the questions are overwhelming and unanswerable, they will be ignored, or you'll be told that the prosecution has no obligation to answer the questions. If you're given anything less than a complete, sensible, and satisfactory response, satisfying you beyond a reasonable doubt to these 15 questions, you will quickly realize that the case really is transparent, and you'll think about the scenario that I just went through for you, and that the term smoke and mirrors that you heard about doesn't apply to the defense. We proved real, hard things for you, things that you can see, things you could take back in that jury room. And accordingly, you'd have to find Mr. Simpson not guilty. When I've concluded, for Ms. Clark's convenience, should she decide to deal with these very troublesome questions, I'm going to leave a written list of these questions here when I conclude. Let me go over these 15 questions with you just briefly. 1. Why? They're on the monitor. Did the blood show up on the sock almost 2 months after a careful search for evidence? And why, as demonstrated by Dr. Lee and Professor McDonald, was the blood applied when there was no foot in it? Think that's a fair question? In this case, let's see if she can answer that question. Question number 2. Why was Mark Furman, a detective who'd been pushed off the case, the person who went by himself to the Bronco over the fence to interrogate Cato to discover the glove in the thump, thump, thump area? Number 3, why was the glove still moist when Furman found it if Mr. Simpson had dropped it 7 hours earlier? As Agent Bodziak told you, Sir McDonald has told you, blood dries very rapidly. 4, if Mark Furman would speak so openly about his intense genocidal racism to a relative stranger, such as Kathleen Bell, how many of his co-workers, the other detectives in this case, were also aware that he lied when he denied using the N-word, yet failed to come forward? Part of Barry Scheck's 4th C of continuing cover-up. 5, why did the prosecution not call a single police officer to rebut police photographer Rocar's testimony that Detective Furman was pointing at the glove before Furman went to Rockingham? That is around 4:30 in the morning. 6, if the glove had been dropped on the walkway at Rockingham 10 minutes after the murder, why is there no blood or fiber on that south walkway or on the leaves the glove was resting on? Why is there no blood on the 150 feet of narrow walkway or on the stucco wall abutting it? And you've been back there. Number 7, for what purpose was Van Adder carrying Mr. Simpson's blood in his pocket for 3 hours and a distance of 25 miles instead of booking it down the hall at Parker Center? Number 8, why did Deputy District Attorney Hank Goldberg, in a desperate effort to cover up for the missing 1.5 milliliters of Mr. Simpson's blood, secretly go out to the home of police nurse Thanoparatus without notice to the defense and get him to contradict his previous sworn testimony at both the grand jury and the preliminary hearing? Paratus was never sworn. We were never given notice. 9, why, if according to Ms. Clark, he walked into his own house wearing the murder clothes and shoes, is there not any soil or so much as a smear or drop of blood associated with the victims on the floor, the white carpeting, the doorknobs, the light switches, and his bedding? 10, if Mr. Simpson had just killed Mr. Goldman in a bloody battle involving more than 24 knife wounds where Mr. Goldman remained standing and struggling for several minutes, how come there is less than 7/10 of 1 drop of blood consistent with Mr. Goldman found in the Bronco? Number 11, why, following a bitter struggle allegedly with Mr. Goldman, were there no bruises or marks on OJ Simpson's body? And you'll have those photographs back in the jury room. Number 12, why do bloodstains with the most DNA not show up until weeks after the murders? Those on the socks, those on the back gate, those are the 2 major areas. Number 13, why did Mark Furman lie to us? Why did Phil Van Adder lie to us? And finally, 15, given Professor McDonald's testimony that the gloves would not have shrunk, no matter how much blood was smeared on them, and given that they never shrank from June 21st, 1994 until now, despite having been repeatedly frozen and thawed, how come the gloves just don't fit? I'm going to leave those questions for Ms. Clark, and we'll see what she chooses to do with and about them. That'll be her choice. But I think you have a right to demand answers. If you're going to do your job in this case, it seems to me you will need to have answers to those questions. Now, there are many, many, many more, but as with everything in this case, there comes a time when you can only do so much. We took 15 as representatives, but I can tell you we had more than 50 questions. But 15 will be enough, don't you think? I think so. In this case, when we started out a long time ago, we talked a lot about truth. And I always like, in a circular fashion, that you kind of end up where you started out. Truth is a wonderful commodity in this society. Some people can't stand the truth. But you know what? That notwithstanding, we still have to deal with truth in the society. Carlyle said that no lie can live forever. We've seen a number of big lies in this case, in this so-called rush to judgment. We've seen lie after lie, so much so that at least two of the major witnesses, Van Adder and Lang, Van Adder and strike that and Furman, their testimony by you may be totally disregarded, further dismantling the people's case. You have that right, you know, in this search for truth. In times like these, we often turn to the Bible for some answers to try to figure out, well, you've got situations like this and you want to get an answer and you want to try to understand. I happen to really like the book of Proverbs. And in Proverbs, it talks a lot about false witnesses. It says that a false witness shall not be unpunished, and he that speaketh lies shall not escape. That meant a lot to me in this case, because there was Mark Furman, acting like a choir boy, making you believe he was the best witness that walked in here, generally applauded for his wonderful performance. Turns out he was the biggest liar in this courtroom during this process. But the Bible had already told us the answer, that a false witness shall not be unpunished, and he that speaketh lies shall not escape. In that same book, it tells us that a faithful witness will not lie, but a false witness will utter lies. Finally, in Proverbs, it says that he that speaketh truth showeth the forthrightfulness, but a false witness shows deceit. So when we're talking about truth, we're talking about truth and lies and conspiracies and cover-ups. I always think about one of my favorite poems, which I think is so very appropriate for this case. You know, when things are at the darkest, there's always light the next day. In your life, in all of our lives, you have the capacity to transform Mr. OJ Simpson's dark yesterdays into brighter tomorrows. You have that capacity. You have that power in your hand. And James Russell Lowell said it best about wrong and evil. He said that truth forever on the scaffold, wrong forever on the throne, yet that scaffold sways the future, and beyond the dim unknown standeth God within the shadows, keeping watch above his own. You walk with that every day, you carry that with you, and things will come to you, and you will be able to reveal people who come to you in uniforms and high positions who lie and are corrupt. That's what happened in this case. And so the truth is now out. It's now up to you. We're going to pass this baton to you soon. You will do the right thing. You've made a commitment for justice. You'll do the right thing. I will someday go on to other cases, no doubt, as will Mr. Clark and Mr. Dart. Judge Ito will try another case someday, I hope. But this is O.J. Simpson's one day in court. By your decision, you control his very life in your hands. Treat it carefully, treat it fairly. Be fair. Don't be part of this continuing cover-up. Do the right thing, remembering that if it doesn't fit, you must acquit. That if these messengers have lied to you, you can't trust their message. That this has been a search for truth. That no matter how bad it looks, if truth is out there on a scaffold and wrong is in here on the throne, Remember that the scaffold always sways the future. And beyond the dim unknown standeth the same God for all people, keeping watch above his own. He watches all of us, and he'll watch you in your decision. Thank you for your attention. God bless you.
Thank you very much, Mr. Cochran. All right, let me see counsel over at the sidebar without the court reporter, please. All right, ladies and gentlemen, contrary to our previous schedule, I'm going to recess for the evening at this time. We will resume tomorrow morning at 9 o'clock. And the lawyers have promised me that we will finish this case. One of the conditions that we go over until tomorrow morning is that we will finish tomorrow afternoon with the rebuttal arguments by the prosecution. I will instruct you, and the case will be yours tomorrow afternoon. And I hopefully we'll at least get it far enough to have you go in, select a foreperson to preside over your deliberations, and then Mrs. Robertson has a list of the exhibits and everything that will be presented to you so you can get organized for the coming days. All right, having said that, please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll see you tomorrow morning, 9 o'clock sharp. All right, we'll be in recess.